These are, if these two matters may kindly come up after the vacation here.
I have no objection, Mother.
Okay, as paid for by Mr. Ayan, will also learn counsel for the appellant and not objected to by the other side. This is the matter again after the ensuing Puja vacation.
I'm on board.
My Lord, in respect of item number 17, hearing list, item number 17. In this case, my Lord, the petitioners were staff of legal service who were challenging the advertisement which was sought to replace them. At this stage, my Lord, I have received an information that the state respondents have now made new recruitment rules, and they have also approved in principle to extend their service. So if my learned friend can produce the relevant material, it can be disposed of.
Let the item be called. This is a motion stage, isn't it?
No, my Lord, I'm mentioning item number 17. 17.
I know. If you want the matter to be disposed,
No, not today, my Lord.
When?
My learned friend has to produce the materials
Okay.
if she can
Next
produce the
week, madam.
materials.
I'll try to produce it next week.
Mr. Victor L. Ralte, learned counsel for the petitioners, submits that there are certain developments in the matter. And the said developments may be placed before the court on the next court date with the cooperation of Ms. Linda L. Fumble, learned additional AG. Stop. Ms. Linda L. Fumble, learned additional AG, agrees to the prayer. In view of above, list the matter. When?
Next week. Next week. After a week.
List the matter again after a week.
Much obliged.
May it please your Lordship. Your Lordship, item number 12, I have a prayer subject to your Lordship convenience. After the motion matter, can it be taken up? It's an
That's what we do in this court. After
Correct.
motion, orders, then
order-
admission, then hearing.
and item number 12 before as the first item in order column.
What is the hurry?
Your Lordship, there's been a lot of jams and I just booked my ticket for today. I made a mistake. I should have. There's a lot of jam in the route to the airport.
All right.
There, much.
All right.
For motion, item number 1.
Yes.
May I please your Lordship? My Lord, the petitioners herein were lecturers under government higher secondary schools. Initially, they were working as a contract basis, and upon completion of 5 years, they were regularized on 19/12/2018. And after completing 8 years, counting from their initial contract appointments, they were claiming for placement to senior grade, as was done to other similarly situated employees. Although they have submitted representation, the same was rejected by referring to the impugned office memorandum dated 22/1/2021 by the state respondents. In fact, the state respondents had notified the Mizoram government employees counting of past service rules 2020, which came into force on 29/5/2020. However, by this impugned OM, my Lord, the said rules was given retrospective effect, as a result of which we were denied counting of our entire past service.
Where's the rules? Page number?
Page number 55. 55, annexure 13, 1-3.
And
Page
what,
number 55.
what is the relevant provision?
The relevant provision is in page number 57, my Lord. Para 5. It says that 1/3 of the past service rendered by so and so shall be counted. If I may take your Lordship to page number 55, the effective date, page number 55,
Yes.
29/5/2020. And now coming to the impugned office memorandum, my Lord. Page number 61. Office memorandum dated 22nd January 2021. This has been issued as for clarifying the said rules, but instead it had amended the said rules by giving retrospective effect in the para 2.
Read.
Para 2(1), my lord, Para 2(1). Para 2(1). The application to these rules covers all employees with prior service rendered as specified under Rule 2 of the Mizoram Government Employees Counting of Past Service Rules 2020, irrespective of their date of regularization, whether before or after the said rule came into force. My lord, the present petitioners were regularized on 19/12/2018. And these rules of 2020, page 55, it came into force on 29/5/2020.
So,
As a result of this, my lord, we were denied counting of the entire contract period for the purpose of upgradation, my lord. If I may take your lordship to page number 36. Page number 36. This is the regularization order of the petitioners. They were in serial number 4 to 10, the present petitioners, my lord. Page number 36. Have you got it, my lord? The present petitioners were from serial number 4 to 10, my lord. And if your lordship may kindly notice those who appeared in the serial number 1, 2, and 3, my lord, they were already considered by the said respondents by counting their entire past service for the purpose of placement to senior grade.
you were contract lecturers.
Yes, my lord.
Then subsequently you were regularized
Yes, my
by
lord.
this office order 19/12/2018.
Yes, my lord.
And now for you to move to the next grade, what is that? Selection grade?
Senior
Senior
grade.
grade.
Senior
Senior
grade. First
grade.
senior grade, then selection grade.
So you are to move to the senior grade.
Yes, my lord.
Now you want your past service to be counted.
Yes, my lord.
Correct? And as per this notification at Annexure 13,
Yes, my lord.
it allows you to count how much? 1/3.
Yes, my lord.
Correct?
Yes, my lord.
Then as per this OM dated 22nd January 2021, what is the embargo
My lord,
list here?
my lord, we were regularized on 19/12/2018,
Yes.
and these rules of 2020 came into force on 29/5/2020. So we were not covered by the rules of 2020.
Oh, you are not covered by the rules
Yes,
of
my lord.
2020.
But
That's what you're saying.
by way of the impugned office memorandum, which give retrospective effect to the rules of 2020, we were denied.
No, see, you were regularized in 2018.
Yes, my lord.
The rules came in 2020. Are you saying that your entire service should be counted?
Yes, my lord.
Not 1/3,
Not 1/3,
entire.
entire.
On what basis?
Page number 40, my lord, 40.
Yes,
Annexure 6 notification dated 4/12/2012, my lord.
yes.
This is has been made under Article 309. Para 1 senior grade, 8 years regular service in the relevant entry grade in teaching professions shall be eligible to enjoy the senior grade. For the purpose of counting of 8 years regular service in the relevant grade, only continuous, uninterrupted service without any break rendered by a teacher in government higher secondary school, as the case may be, shall be taken into consideration. And
So,
as per this, my lord, we were entitled to count our entire past service, my lord.
but you were only regularized in 2020.
18. 18.
So your service should count from your initial date of appointment and contract basis.
Yes, ma'am. That is what
How is that?
the way it was done to other similarly situated employees on the basis of
Maybe.
this notification.
Maybe it was done, but
If the rules of 2020 and the impugned office memorandum is not existent, my lord, we are entitled to this. This has been given to all other similarly situated employees.
I understand, Mr. Victor. There's no such kind of provision which says that on your regularization, your entire past service should be counted. You're giving an example only of some persons who were given the benefit of the entire service. Now, your regularization at page 36,
Yes, my lord.
what is the effective date of your regularization?
With immediate effect.
So, your regularization only starts from 19 December 2018 for the purpose of government service.
Yes, my lord, that is correct. But my lord, by this notification on page number 40, my lord, the continuous service which we have rendered without break in government higher secondary school can be counted. Prior to our regularization, my lord, we rendered our contract service under the same government higher secondary school on contract basis.
That is why you were regularized uninterrupted contract service.
Yes, my
had,
lord.
had there been breaks in between, you would not have been regularized. There were no interruptions. You had continuously worked on contract basis, so they regularized you. Now, notification of 4th December 2012, it just says that for the purpose of counting 8 years, regular service in the relevant grade, only continuous uninterrupted service, even though it's on contract basis, will be counted. That is not there.
That is the way it is applied, my lord. If I may take your lordship again to page number 36. This
Yes.
serial number 1, 2, and 3, my lord, kindly note that these names. And if I may take your lordship again to page number 42.
Yes.
These 3 persons were already considered.
Where is that?
Page number 42. And moreover, my lord, if I may take your lordship to page number 63. Page number 63,
63.
annexure 15. This is notification dated 19 December 2022. On the bottom of the last paragraph, my lord, on the 62
Not 19
page.
December, it's 12 December.
12 December 2022. Whoever who were regularized after enforcement of the rules of the 2020, this last paragraph, this clause is added to the regularization order. In our case, my lord, at the time of our regularization, these rules is not in exist.
Why were you not regularized then along with, why were you not considered along with those 3 persons?
My lord, my representation was rejected as a result of the impugned office memorandum, which give retrospective effect to the rules of 2020.
How does it give retrospective effect? Let's see.
Page number 61, my lord. Page number 61, para 2.1. The application to these rules covers all employees with prior service rendered as specified under Rule 2 of the Rules of 2020, irrespective of their date of regularization, whether before or after the said rule came into force.
Okay, that is one thing. My question again, these 3 persons were given the benefit of counting their entire past service.
Yes, my lord.
Why were you not considered at the time? Why only these 3 persons? Because there, as many as 12 people were regularized by this
Yes, my lord.
2018
Yes, my lord.
notification. What happened?
We were claiming similar benefits, but they were referring to this impugned office memorandum.
No, your claiming is different. Your claim came later on. Now, what about these 3 persons? Why are they separately given this benefit? Why were you not considered?
At this stage, my lord, I'm not aware of it, the reasons.
It is not that there has to be a vacancy in the senior grade for you to be promoted. Is it like that?
No, my lord, there's no question of vacancy.
That's why.
Once we completed the eligibility
That is
criteria.
why 3 persons have been selected when the rest of you have been left out. When did you file your representation? Date
4th June 2024.
2024.
4th June.
And what is your reply?
Page number 53, my lord. they were referring to could not be considered as per the provision of so and so. This impugned office memorandum 22/1/2022, 2021, para 21.
22, what is that?
The effective date of the rules of 2020, which they have
Okay,
amended.
the Office memorandum. So now what have you challenged here?
Now we are challenging this impugned office memorandum 2021,
Yes.
22/1/2021,
And
and the rejection letter of our representation.
rejection letter is at page
53, my lord.
53. Both side printed is allowed, but it creates a lot of inconvenience. You see, we have to look both sides. Then '22, 2022, then this rejection, then what else?
Office memorandum 22/1/2021 is the impugned office memorandum, and annexure 11, page 53.
So you're basically challenging annexure 11 and annexure 14.
Yes, my lord.
Correct.
Yes, my lord.
We'll issue notice at this stage.
Yes, my lord.
Heard Mr. Victor L. Ralte, learned counsel for the petitioners, who submits that the petitioners were appointed as lecturers on contract basis, and their services were subsequently regularized via office order dated 19/12/2018 with immediate effect. Stop. He submits that in order to move to the next higher grade of senior grade, 8 years regular service in the relevant entry grade without interruption is required to be taken into consideration in terms of notification dated 4/12/2012. Stop. Although the petitioners have been continuously working as lecturers, they were denied the counting of their past services in order to move to the senior grade. On the ground that the Mizoram government employees, bracket, counting of past service, close bracket, rules 2020, permits only counting of 1/3 past service rendered on contract basis. For the purpose of promotion. Stop. Though the rules of 2020 have been made effective from 29/5/2020, but the state respondents, by issuing office memorandum dated 22/1/2021, have made the rules of 2020 applicable to all lecturers irrespective of their date of regularization, and thereby, creating a bar for the petitioners to get the benefit of counting their past service for the purpose of promotion to the senior grade lecturer. Stop. Next para. Mr. Victor L. Ralte, Learned Counsel, submits that the petitioners were regularized on 19/12/2018, whereas the rules of 2020 came into force only with effect from 29/5/2020. And therefore, the rules of 2020 is not applicable to the petitioners. Stop. The office memorandum dated 22/1/2021 has also been issued. Arbitrarily to deny the petitioners the chance of being considered for promotion to the senior grade by counting their past services rendered on contract basis. So therefore, the Learned Counsel submits that the impugned communication dated 30/7/2024 rejecting the representation of the petitioners and the office memorandum dated 22/1/2021, insofar as retrospective effect has been given to the rules of 2020, should be set aside. Next para, the Learned Counsel also submits that three similarly situated persons who were regularized along with the petitioners have been allowed the benefit of counting their past services and were promoted to the senior grade by notification dated 2/9/2021. Stop. Therefore, the petitioners, being similarly situated in all respect, they should also be given a similar benefit of promotion. Next para, in view of above, issue notice of motion returnable by 4 weeks. Ms. Louis, Learned Government Advocate, accepts notice on behalf of
All.
Respondents number 1 to 5, Your Lordship.
all the respondents, and therefore no formal notice is required to be served on the said respondents. The petitioners shall serve requisite copies of the writ petition to the Learned Government Advocate within 2 days, if not already done. List the matter again after 4 weeks. State respondents to file their counter affidavit in the meantime.
Deeply obliged.
For orders, item number 12.
Your Lordship, there is an application for amendment of the writ petition. What has happened, Your Lordship, in the affidavit in opposition filed by the respondent, they are relying upon 2 documents, which though dated prior to our date of filing of the writ petition, those documents were never furnished to us. Therefore, we were not in a position to assail those 2 documents and without assessing the said documents, we will be gravely prejudiced. In that circumstances, we have preferred this instant application, second for amendment of the writ petition, Your Lordship. Those documents, Your Lordship will find at page 25 of my application, which they annex as annexure R1 to their affidavit in opposition. This is an inspection report. It's OEM analysis of the DU part. This was never furnished to us prior to the filing of the writ petition. It is dated 27/1/2023. Writ petition was filed on 2nd of February 2023.
No, just a minute. Which annexure?
Your Lordship, at page 25, we have marked it as annexure 13.
Okay, and what is the date?
This the date Your Lordship will find at page 28, 27/1/23. It's a signature of the Your Lordship, may see.
Page 20?
28.
28, there's no signature.
Sorry, Your Lordship. No, the reference date is that. Your Lordship, just, I'm so sorry. Your Lordship, page 33.
30?
33.
Twenty-seven 1/2023.
Yes.
What is this document?
This is a OM analysis, the original equipment manufacturer's analysis of the DU. Your Lordship, this is with regard to they are alleging that I have tampered with the petrol pump unit, dispensing unit. This is a report furnished by the original equipment manufacturer. This report was never ever furnished to us, and therefore we could not challenge the findings recorded herein at the time when we filed the writ petition. The next is
But you are aware about the fact that they had come for inspecting the equipment?
subsequent to the issuance of the show cause notice. Yes, they came. That I have already pleaded in my writ petition.
Who are the inspecting authority?
Some of the officials of the respondents came, Your Lordship. If Your Lordship,
So this is the report.
this is the report.
So, but the thing is that you were aware about the inspection having been done,
Yes,
but you do not have the report with you.
right,
So in the counter affidavit, they've come up with a report.
right.
And what does the report say?
The report says, Your Lordship, basically that they find some irregularities.
You come to page 33 itself. It is established that dispensing unit has been manipulated for delivery of fuel. We hereby reiterate that we are committed towards taking into measures so and so, so and so. So this finding is against you.
Yes, Your Lordship. That's why we need to challenge this.
So this report was not given to you?
Yes, Your Lordship.
Now, what is the otherwise modalities? They come and check, the report is given. Are you not given a chance to justify your action?
No.
They simply take the action. They close down the...
It's very surprising. If Your Lordship just see the next letter at page 37,
Yes.
this is the finding of IOCL after I have given a reply to my show cause, where they say, in respect of some of the allegation that they level against me, in the end, you are hereby warned not to repeat such irregularities in future and follow the corporate, and corporation may take stringent action in case of such irregularities in future. There were 6 allegations. Against the 6 allegations, in respect of 4, they just give me a warning.
6 allegations
6
in
allegations,
respect of 4.
they give me a warning.
And what about the other 2?
Nothing is mentioned in this. So my contention now,
So this report covers the other 2?
now they have not raised any allegation against that in this report. And this report precedes the report at 27-1. This is dated 23/11/2022.
What have you challenged in the writ petition?
I had my challenge before the writ petition was
No,
that
not the subject. I mean the order, the date of the order, whatever.
the date of the order is the show cause notice, Your Lordship.
What is that? So was notice dated
25/8/2022.
8.
Yes.
But this letter is 23/11. You have
This
warned.
was never supplied to me.
No, this is only giving you warning.
Yes. Because my contention was that, look, the punishment prescribed for this were 15 days of suspension. You, by not taking any action in pursuance to my reply, you are prolonging my punishment indefinitely.
Show me what is that penalty given to you or whatever impugn order in the remain writ petition. What have you challenged? This is reply, this is opposition, this is objection, this is the writ petition. Impugn letter dated 25/8. This is the show cause.
Yes, Your Lordship. Because subsequent actions were not notified to me, anything.
25/8. A team of officers for quality so and so visited so and so. Upon inspection, team found so and so. 1, 2, 3, 4, 5, 6, 7. There are 7 findings.
And page 60, they say your reply should reach the undersigned.
In this connection, you are directed to explain how this type of irregular has happened. You should reach this unassigned by 10 days. So,
I gave my reply, and thereafter no action was communicated to me. And I approached this honorable court that prolongation of this
your reply has come after 2 months? Almost 2 months?
Yes, Your Lordship.
Why? They say 10 days.
But
Was there any extension?
we sought for some extension.
It was given to you.
Yes, Your Lordship.
Then after the reply, what is the further
Then
step?
this letter comes, according to them, this was the letter that they issued now in the affidavit in opposition.
Warning letter.
Yes. In respect of where they only take care of only 4 of the things. Other 2,
So by filing this IA, you want to incorporate this 27/1/23
and 2/2/23.
and
Oh, sorry, 27/11/22 and 27/1/23.
No, just a minute. See the date. It looks like 27/1, not 11. Page 33.
Page 37 is 23/11, 33 is 27/1/23.
Exactly. 27/1/2023.
Yes, that one document. And the next document is
You filed your writ petition on 1st February 23.
it came up on 2/2/23.
And this letter was issued to you on 27/1/23. I mean, the report. Sorry.
But
The
it was never served on me, Your Lordship. That's my categorical statement here, Your Lordship, in my.
Then what about 23/11/22? Warning.
That also never served on me.
But the address.
It's addressed to me.
It was addressed to you.
Addressed to me, but there's no service done, Your Lordship.
So how do you want to incorporate this Where's your application?
Paragraph 8 onwards, Your Lordship, I wanted. Paragraph 8.
Is it coming for the first time? This IA?
Is it coming for the first time?
No.
No. They were supposed to file an objection if they have any objection to my prayer.
It was adjourned when it was listed on 9/8. Objections may be filed to IA, so advise. So, Mr. N. Barua,
Yes, my lord.
are you going to file objection?
My lord, my instruction is that the IA may be allowed with liberty to the IOCL to clarify certain points on this facts they've raised by way of an additional affidavit only.
Surely. See, if you have no objection, we allow the amendment, then he'll file a recast.
Yes.
And against the recast, you will have the liberty to file your additional affidavit in opposition if you want to.
Yes, my lord. That is what I.
All right, please write down. Heard, Mr.
D. Senapati.
D. Senapati, learned counsel for the applicant, stroke writ petitioner, who submits that by filing this application, the applicant seeks amendment of the writ petition in the manner as laid out in the application. Stop. The learned counsel submits that amendment of the writ petition is necessitated in view of the fact that the respondents have come up with two documents in their counter affidavit to the writ petition, namely the lab analysis report 27/1/2023, which is against the applicant stroke petitioner, and secondly, the warning letter dated 23/11/2022 addressed to the applicant stroke petitioner, which otherwise was never received by the applicant stroke petitioner. Stop. The learned counsel submits that unless the two documents are brought on record and the applicant / petitioner allowed to challenge the same, grave injustice would be caused to the petitioner. Next para, Mr. N. Barua, learned counsel appearing for the opposite party, fairly submits that the applicant may be allowed to amend the writ petition, but he submits that the opposite party / respondents may be allowed to file additional counter affidavit. Stop. Next para, considering the submissions made by the learned counsels for the parties, and upon perusal of the materials available in the application for amendment of the writ petition in the manner as laid out in the application is hereby permitted. IA stands disposed of as allowed. Next, in the main writ petition, you write, in view of the order passed today in IAC number 121 of 2024, allowing the amendment of the writ petition, the petitioner shall file a recast petition within a period of
4 weeks, Your
4 weeks from today, after serving requisite copies of the same to the learned counsel for the respondents. Stop. Upon filing of the recast petition, the respondents would be at liberty to file their additional affidavit in opposition, if so advised. List the matter again on
30th of October, Your Lordship, subject to
Mr. Barua.
Yes, my
30th
lord.
October.
Yes.
on-
That, good enough.
Just a minute. Can we have it one day before that? 29th.
Yes, Your Lordship.
29th of October 2024.
Your Lordship, the interim order passed earlier Maybe.
The interim order passed earlier shall continue till the next date of listing.
Much obliged, sir.
Much obliged.
Item number 10.
Yes, what is this?
My lord, this is the petition for considering the delay, my lord. Last occasion, I filed an additional affidavit, my lord. And
You are the applicant.
yes, my lord.
How many days delay?
My lord, there is 400, my lord, 85 days, my lord.
485.
85 days, my lord. Last occasion, they granted, I filed additional affidavit.
Yes.
If it please your lordship, I would like to pray for extension of time for filing of WO against the additional affidavit.
1 and 2 is filed. Miss Linda, you have for 1 and 2.
I'm for respondent 1 and 2.
Are you not filing?
No, my lord.
Okay. 1 and 2, you have filed affidavit of opposition.
My lord, initially, when I was filed, no, that they filed affidavit of opposition, my lord. They have filed and I have filed an additional affidavit, my lord.
I understand.
Yes, ma'am.
You have filed your counter affidavit. You are for 1 and 2.
Yes,
Now they have filed an additional affidavit. So against that additional affidavit, you want to file counter. How much time?
2 to 3 weeks maybe.
Sorry?
2 to 3 weeks maybe, my lord, after vacation.
Mr. Mehdi, when are you coming back?
My
We'll
lord,
fix the date.
in 29th of October, my lord.
29 October. List the matter again on 29 October as paid for by the parties. In the meantime, the respondents may file additional counter affidavit to the additional affidavit filed by the applicants.
Much obliged, my lord.
Item number 11.
My lord, I would like to tender my apology because in the last court date I have submitted that only 2 witnesses have been examined. I believe the PW number 4 was also examined subsequent to the filing of this petition, my lord. So that was the apology that I would like to,
So together, 4 witnesses have been examined
yes,
out of 5 witnesses.
my lord. So
You should have been updated
yes, since the,
because I tell you why.
my lord.
Where is that paper? On 24th of July, 2024. Okay, all right. PW3 and PW4 were examined, both examined on 9/8/2024. So what remains? Okay, before that, PW1 and 2 were examined on 21/5/2024, 3 and 4 on 9/8/2024. Now what remains is only one PW, that is PW5, and who is also the IO.
Yes, correct.
He has not been examined.
Has not been examined.
But what is the date of the next court date? Any instructions?
3rd of October, my lord.
3rd of October.
Yes, my lord.
They have sent the scanned copy of the records, but without the order sheet. I mean, we have to ask them from now on. In any other criminal appeal also, order sheet should be there. Because sometimes we need to check back when the charge was framed, when the witness was examined, all that. Third of October is just round the corner now. So why not why not we request the learned trial court to speed up complete the trial and complete it within October itself?
My lord, yes, your lordship is correct, but On the other hand, since this is a bail application, if your lordship may kindly allow me to make one small submission on with regard to violation of section 52A, wherein the Honorable Supreme Court in some cases had released the applicant on bail due to violation of section 52A of the NDNPS Act. When there is no primary evidence, the trial itself stood vitiated. I would like to place some of the judgment authorities on that. (2023) SCC Online SC 918. I have submitted that there are no photographs taken in the presence of the magistrate, which shows that section 52A was not complied.
52A subsection 2B.
Yes, my lord. Correct. Here it says taking in the presence of such magistrate photographs.
52A 2B.
For that purpose, I would like to rely upon the Honorable Supreme Court judgment in 2023 SCC Online SC 1328.
Photograph.
Paragraph
Is it dealing with photograph?
is dealing with section 52A.
Not photograph.
Your lordship may have to lay down some law on this point. We need some precedence, my lord.
No. See. No, you were.
Yes, I'll come to that.
Which one are you going to rely upon?
I'll
for-
rely first on 2023 SCC Online SC 1328. Yusuf Ed Asif versus State. Now this is with regard to section 52A. I'll just take your lordship to
Yes.
para 16. This is a case involving 20 cases of heroin, the case which I'm relying upon. Para 16.
Yes.
With your lordship permission, in the absence of any material on record to establish that the samples of the seized contraband were drawn in the presence of the magistrate and that the inventory of the seized contraband was duly certified by the magistrate, it is apparent that the said seized contraband and the samples drawn therefrom would not be a valid piece of primary evidence in the trial. Once there is no primary evidence available, the trial as a whole stands vitiated. Now, I had submitted before your lordship in the last court date that the person to whom or the magistrate to whom the inventory was made for certification was not known. Name of the magistrate was not mentioned, and there are no photographs. In the charge sheet which the Honorable Court has supplied upon us. So in this case, it is my humble submission that section 52A, subclause 2, subclause B, has not been complied. It appears, as your lordship might have on the case record, which is not available to me, my lord, there has to be photographs taken in the presence of the magistrate. When I specifically raise a point that
Miss Linda, you just have a look. This. Yes, there has to be a photograph, then
in the presence of the magistrate, and the prosecution case is doubtful on account that we do not know who is the magistrate who had allegedly appended her signature on the inventory.
you know the magistrate.
I don't know the magistrate who has signed.
Then
my
why do you say her?
No, maybe that maybe a slip of tongue, my lord. Because the ladies are more.
Because the CJM is a lady, you know, that's why you say her.
Maybe. I'm sorry to say that, but I should not have said that. But since the ladies are more,
See, the IO says in the charge sheet, obtain certificate of correctness of the inventory from CJM ISO,
CJM is that's
as
correct.
a judicial
The
district.
IO has said that. But what had happened thereafter, Your Lordship will see. I have already pointed out before Your Lordship, if Your Lordship may kindly come again to page 58 of my bail application. This is the application made to the CJN. Now, at the bottom of the page, there is a signature of Judicial Magistrate First Class. Thereafter, at page 59, it is not the CGM who had signed that. Obviously, it's the signature of Judicial Magistrate First Class. And on page 60 as well, page 61, apparently the application was submitted to the Chief Judicial Magistrate. If I may not be tedious to Your Lordship, there has to be some order made by the CJM or the Judicial Magistrate that they allow this inventory, that they certify this inventory made by the IO. See, this inventory is correct.
Under what provision?
Under the section 52. Section 52. Your Lordship will see at section 52A sub clause 2. I'll read this, my lord.
So that's why, see, you come to page 59, certified that the seized article brought before me is with seal intact, from which the following samples are drawn and packed in my presence. Serial number 1 to 11.
Now the application was made before CGM. Till date, there is no order allowing that the inventory prepared by the IO is correct.
This is the certification, page 59 of your bail application.
Yes, it is the certification.
What more do you require beyond that?
No, my point is that, my lord, since this application was submitted to the CGM and the certification was made by Judicial Magistrate First Class, there has to be some order that this application should be certified by Judicial Magistrate First Class from the CGM. Since this signature above the seal of the Magistrate First Class does not mention that this person, this Judicial Magistrate certified this. Only the signature is there.
Okay. So?
Now, section 52A is the ground wherein I can also take the benefit of allowing me to be released on bail if it please Your Lordship, because I have just submitted the citation, the authority, which says that when the primary evidence itself is not there, trial itself stood vitiated.
So how do we vitiate the trial in a bail application?
No, Your Lordship will see that since there are no photographs.
See, what was the consideration before the Supreme Court in this case?
It's with regard to seizure and sampling done in violation of section 52A2. Your Lordship will see that the Honorable Supreme Court has
See,
highlighted.
there is aggrieved by his conviction and sentencing by the trial court and its affirmation by the High Court. A1 alone has preferred the present appeal,
Yes, my lord.
assailing the judgment of the High Court dated so and so. So, this is after the trial.
After the trial, correct.
When judgment was pronounced, he was convicted.
Correct.
Appeal was filed by the High Court. Before the High Court affirmed the judgment. Then it went to the Supreme Court. Then the Supreme Court has dealt with this section 52A.
Correct.
The
Now,
observation is to the effect that in the absence of any materials on record to establish that the samples of the seized contraband were drawn in the presence of magistrate and the inventory of the seized contraband was duly certified by the magistrate, it will not be a piece of primary evidence in the trial. And once there is no primary evidence, the trial itself is vitiated.
I agree.
This
Now,
is what it said.
in my case as well, when section 52A subclause 2 subclause B stipulates that
See, you are asking this court to take a prima facie opinion that the trial is vitiated.
no,
Now, there is one person, important witness, that is the PW5, who is the case IO himself, yet to be examined. That's why at the outset I had said, since the date is not very far away, 4th of October, we may see what happens there.
my lord, since
And I may not dispose this bail application at this stage and fix a date just after the examination of that.
my lord,
Once you can produce the copy of that, we may consider.
my lord, then this case may be adjourned till the examination of the IO.
What do you say, Miss Linda? Only one person is left.
Yes, my lord. Only one person is left. Let the trial court decide first, my lord. Because out here we're dealing with bail, my lord, and there is this section 37. And trial is almost completed at this stage. It's not a favorable time for bail at this stage, my lord.
Have you found anything in the records?
I have not seen, I found,
Photograph
is not here in
the identity of the judicial magistrate, then what else?
So that is quite a serious matter, my lord.
That will be decided by the trial court, my lord. in the
No, your
trial.
lordship is seized of the matter, my lord. Section 52 cannot be taken lightly. At this stage itself, that is my humble prayer.
Bail is, my lord, under section 37. So what we have to consider is the twin conditions that has been imposed. Otherwise, this will be decided by the trial court, my lord.
My lord, let me take your lordship to the, I'll just rely upon just order passed by the High Court of Judicature of Lord Rajasthan in Amjad Khan versus State of Rajasthan.
What about this 2023 SEC online 918 you had shown me?
Yeah, I'll come to that, my lord. It's with regard to section 37, where section 37 can be dispensed with when the trial is yet to commence, though the charges have been framed.
But here the trial is not yet to commence, it's almost ending.
Yes. So section 37 can be dispensed with as per this judgment. May I take your lordship to the order passed by the High Court of Rajasthan,
Just a minute, let us see the section 37 first.
my lord?
In the absence of criminal antecedents, the fact that petitioner is custody for the last 2.5 years, who has satisfied the condition of 37, can be dispensed with at this stage. What is the reason?
Due to delay in completion of trial. I have been in custody for 404 days, as on today. Now that is more than a year, my lord. So,
The case you are relying is 2.5 years.
yes. Yeah, that's correct, man. The yardstick is different.
Okay, now Rajasthan High Court.
Rajasthan High Court, it deals with section 52 as well. Para 7, page 3.
Yes.
I'll read this from that beginning, my lord. On a perusal of the record, it would be also clear that admittedly mandatory provision of section 52A of the Act has also not been followed, as seizure officer did not get the proceedings under section 52A conducted in this case before a magistrate or a gazetted officer. Honorable Court, in the case of Manggilal so and so, it has been propounded that such inventories, photographs, and list of samples drawn with certification by magistrate would constitute as a primary evidence. Therefore, when there is non-compliance of section 52A of the Indian PS Act, where a certification of a magistrate is lacking, any inventory, photograph, or list of samples would not constitute primary evidence. The obvious reason behind this provision is to inject fair play in the process of investigation. Section 52A of the Indian PS Act is a mandatory rule of evidence which requires the physical presence of a magistrate, followed by an order facilitating his approval, either for certifying an inventory or for a photograph taken apart from the list of samples drawn. My lord, may I rephrase this? Followed by an, which requires the physical presence of a magistrate, followed by an order facilitating his approval. My lord, in this case, we do not know whether an order was passed by the CJM or the judicial magistrate, first class. Now, the photographs itself also constitute primary evidence, as my learned friend has just gone through the case record, scanned copy. She had not found the photographs.
Whereas in this case also, certification was lacking. Photograph was there.
Yeah.
So photograph itself also is not no value unless there's a certification.
Yes, my lord. And here itself, there is no photographs.
Here there's a certification, but no photograph.
No photographs, yes. So there's a piece missing, which renders the prosecution story vague and doubtful, my lord. Now, may I continue with your lordship? With the permission of your lordship? Para 8. In Mohammed Khalil versus the state of Telangana, so and so, the Honorable Apex Court has ruled that admittedly, no proceedings under Section 52A of the Indian PS Act were undertaken by the seizure officer for preparing an inventory and obtaining samples in presence of the jurisdictional magistrate. In this view of the matter, the AFSL report is nothing but a waste paper and cannot be read in evidence. Para 9. In my considered opinion, the submission made by learned counsel for the applicant cannot be completely overlooked. Having regard to the facts and circumstances of the case and having considered the position in respect of Section 52A of the Act and other arguments addressed by the counsel for the applicant as noted above from the Challan papers and evidence produced, it prima facie did not show the compliance of Section 52A of the Act and seizure by competent and authorized officer in its true spirit. In such a situation, it assumes importance that in absence of proper explanation from the prosecution, it prima facie significantly undermines the case of the prosecution, and thus the entire search and seizure proceedings are prima facie vitiated. Para 10. Having considered the material available on record, the arguments advanced by counsel for the applicant, particularly the facts narrated above and the fact that the applicant is in custody since 1/10/2022, the bail rejection order goes to show that the applicant is not involved in any other case under the Indian PS Act. That trial is likely to take its own considerable time, and taking note of all these aspects, I do not intend to go into the merits of the matter, but of the considered view that the rigor of Section 37 of the Indian PS Act is duly satisfied, forasmuch this court feels that the applicant has available to him substantial grounds so as to question the prosecution case, and no useful purpose would be served by keeping the applicant in detention for an indefinite period. Therefore, I am inclined to grant indulgence of bail to the applicant at this stage. My lord, as I understand on reading this observation, the substantial grounds which the Honorable Court has said is due to non-compliance of Section 52A. In this case, in this particular case, the applicant was in custody for around 1 year, 5 months. So prima facie, Your Lordship can take all these matters into consideration in granting bail, my lord. That is my humble submission, and I beseech Your Lordship to take into consideration that the primary evidence is not there and there is no order of the magistrate allowing the certificate, allowing the application made by the IO for certification of the inventory, which makes the whole case of the prosecution doubtful.
Yes, that's it.
That is my prayer, my lord.
Yes, Miss Linda.
My lord, the citation which my learned friend has relied upon is, the facts are different, my lord, in this case. Which he has relied upon says that there is a violation of section 52A, coupled with the fact that the trial has not even started and he was already in jail for more than a year. Out here, my lord, we have almost completed the trial. We have just one witness left, and who is to be examined on 3rd of October, and trial will be completed by the time, my lord. So my prayer is that, my lord, at this stage, bail may not be granted to the petitioner, and the trial court will be allowed to carry on with the trial at this stage. And since, my lord, the petitioner is an outstation, my lord, he's from North Tripura, there's a danger of him absconding also.
There's one applicant, is it? Or two?
Yes, my lord.
One.
There's only
Two
there are
accused.
two accused, but only one applicant. in
Oh, no,
this.
only one applicant before the court.
Yes.
All right, we'll consider and pass necessary orders.
My lord, I'll just, if Your Lordship allow me, I'll just make a reply, short reply.
Oh,
I am in custody for more than a year. My learned friend has sought to distinguish the case which I produced and my case, but I have been in custody for more than a year,
85 days.
404,
How many days?
404 days.
404.
In the case of Rajasthan as well, it's 1 year and 5 months. I beseech Your Lordship to take into consideration all the factors which the prosecution have failed to comply, which is a mandatory provisions of law. Yeah. I'm obliged.
The records are here. Give the records. You send it to the chamber.
For admission, item number 2 to 6.
Yes, my lord, the writ appeal is still pending, my lord. Last occasion matter was listed, my lord, but private respondent, my lord, took time, but for personal difficulty of the advocate, my lord. The writ appeal is still pending in a principal bench, my lord. Last time the matter was listed, my lord, but private respondent advocate, my lord, took time, my lord. And fixed on 24th of October, my lord, again, my lord. It was adjourned, my lord.
24th of October.
Yes, my lord. So, my lord, the matter may be fixed again, my lord, on November, my lord.
Number, what's the law?
November, 4th November, my lord.
Yes.
It's okay, Lord.
All right. Mr. Right like this. Parties are represented by the respective councils. Stop. Mr. S.K. Mehdi, learned CGC, appearing for the Respondent Union of India, submits that writ appeal number 265/2023 is still pending and the same is due to be listed on 24/10/2024. Stop. He submits that since the outcome of the writ appeal will have some bearing in the instant writ petitions, the instant writ petitions may be adjourned and be listed again on 4th November.
Yes, ma'am.
Can we have it one day before or after? 5th, 3rd?
Fourth, my lord, fourth, and I come on Sunday, my lord. If fourth, my lord, I come on Sunday, my lord, this.
Sorry?
If fourth, my lord, I can come Sunday, my lord, this.
Okay, 4th of November, isn't it? It's Monday. Okay, 4th of November. I was looking at December.
Yes.
That's what.
Item number 7.
7, my lord, I am filing. Same issue, my lord. 7, my lord. Only there is interim order, my lord. Just filed by Union of India, my lord. Same issue, my lord.
Same issue.
Yes.
Writ appeal also same thing.
Yes, ma'am. Only there is interim order in this case, my lord.
Okay, as paid for by Mr. S.K. Mehdi, learned CGC, appearing for the petitioners. List the matter again on 4th of November 2024. Interim order passed earlier shall continue.
Item number 8.
May please, Your Lordship, if I may take Your Lordship to the order dated 7th of May, 2024. In fact, Your Lordship had already heard this matter earlier. If I may read this order, Your Lordship.
Yes.
The petitioner was appointed as constable under the Mizoram Armed Police on 16 February 1988. He was promoted to the rank of Nayak on 1/8/1996 and to the rank of Havildar on 27/2/2001. The petitioner was further promoted to the rank of Sub-Inspector on 26/9/2008. While promoting him to the post of Sub-Inspector, an issue arose regarding the grade pay and pay band applicable to the petitioner. After the then DDA of the police headquarters consulted the respondent number 5, that is the Chief Controller of Accounts and Treasuries Department, Government of Mizoram, the petitioner's pay on promotion was fixed as per Rule 15 of the Mizoram Revision of Pay Rules 2010, notified by notification dated 6/8/2010, Annexure 2. Accordingly, the petitioner was placed in PB2 9,300 to 34,800 with a grade pay of 4,400 in the pay band, which added up to 14,920. As per the last pay certificate, of the basic pay of the petitioner in the rank of Sub-Inspector of Police is 57,400, Annexure 3. The petitioner was promoted to the next higher post of Inspector on 9/5/2022. But however, despite his promotion, his basic pay is 55,200, which is lower to the basic pay received by him in the lower rank of Sub-Inspector of Police with a difference of 2,200. Mr. A.R. Malhotra, learned counsel for the petitioner, submits that the same post cannot have two pay scales, that is, one for the promotee and the one for the direct recruit, as it will be in violation of principles of equal pay for equal work. He has placed reliance upon the order dated 23/3/2017, passed by the Division Bench of Delhi High Court in WPC number 2634 of 2017, Government of NCT of Delhi versus Somveer Rana. The Learned Counsel submits that on further challenge made by the NCT of Delhi through diary number so-and-so before the Apex Court by order dated 1/9/2017 dismissed the SLP and directed the Government of India to come up with appropriate circular. Pursuant thereto, Learned Counsel submits that the Government of India in the Ministry of Finance, Department of Expenditure, had issued the office memorandum dated 28/9/2018. Learned Counsel submits that as per the stand taken by the state respondents in the counter affidavit, the office memorandum is not applicable in the case of the petitioner as it has not been adopted by the government of Mizoram. Learned Counsel submits that the same cannot be accepted in view of the fact that it was clearly a directive of the Apex Court while dismissing the SLP filed by the NCT of Delhi in the aforesaid referred case. In view of the above, the issue to be decided is as to whether there can be different pay scale, pay band for direct recruits and promotees in the post of sub-inspector and inspector. Mr. Samuel Valanshiata Sangte, Additional Advocate General, shall obtain instructions and inform the court about the pay band of a direct recruit and the pay band of a promotee in the post of sub-inspector, inspector by the next date. So, in pursuance of the direction of this Honorable Court, Your Worship, the state respondents have submitted an additional affidavit.
Why two posts have been mentioned here?
Yeah, the controversies regarding the pay of the sub-inspector only.
Yes, the order of this court has said sub-inspector and inspector.
Inspector.
Sub-inspector is a feeder post for inspector.
For inspector.
Then has any instruction come?
Yes, Your Worship, they have submitted an additional affidavit in June 2024, 27th June, I think.
What do they say?
They have clarified that there are no separate pay scales for promotee and direct sub-inspectors. Paragraph 2, Your Worship. Answering respondent in compliance of this Honorable Court's order dated 24th of May 2024 submits that there are no separate pay band of direct recruit and pay band of promotee in the post of sub-inspector of police in the Mizoram revision of pay rules 2010, notified by number so-and-so dated 6/8/2010, wherein the pay band of sub-inspector and inspector of police may be seen at serial number 478 and serial number 480.
What is the annexure here? Revision of pay.
Yes. Page 27 is the relevant page, Your Honor. Serial number 478. Pay of sub-inspector. It is the same for direct recruits and promotees.
478.
Serial number 478, sub-inspector.
Existing pay 65, 1050, then existing pay. How do they say there's the same? Because there's no other head.
Yes. For
Only
the
there's one head which
for
says sub-inspector.
Sub-inspector.
Does not distinguish.
Between promotee and direct.
Why this had come up otherwise?
Yeah, the reason is, Your Worship will see,
Your pay anomaly?
Your Worship, under the revision of pay rules 2010, that is when the sixth pay was adopted by the government of Mizoram. There were two methods for fixation of pay.
Sixth pay. Is it annexure 2?
Annexure 2, Your Worship. These are the Mizoram revision of pay rules 2010. And under this, although as per the additional affidavit, the pay of the sub-inspector is the same. I mean, there's no different pay for promotee and direct. But if your Lordship will see Rule 13 at page 32. So Rule 13 talks about fixation of pay on promotion on or after 1/1/2006. And this was the formula applied by the state respondents for fixation of pay on promotion on or after 1/1/2006. But page 33, Your Worship, I have extracted only the relevant portion. At page 33, rule number 15. Rule number 15. So under rule 15, they have made this table number 2. And according to this, the pay of direct recruits appointed on or after 1/1/2006 as stipulated in table 2 is to be fixed. And if your lordship will see from at the bottom of the page, PB2 9,300 to 34,800. Grade pay is 4,400. Pay in the man 10,520. And the pay is fixed at 14,920. So because of this, there were two different pays for promotees and direct recruits. And when the pay of the promotees was fixed as per Rule 13 on their promotion on or after 1/1/2006, their pay was fixed below the pay of direct recruits, whose pay was fixed as per Table 2 under Rule 15.
Direct recruits getting the pay in which post? Sub-inspector.
Sub-inspector. So due to this,
But where do we get the head sub-inspector here?
no, that is why, Your Worship, we have to read it with this, the additional affidavit. If your Lordship will see the additional affidavit.
Filed by the respondent?
Yes, page 27.
Yes.
Serial number 478, sub-inspector. So the pay band of a sub-inspector is PB2. Corresponding pay band is 9,300 to 34,800 and grade pay of 4,400. So this is the pay band of the sub-inspector, irrespective of whether he is promotee or direct recruit. But then when we refer to the rules of 2008, revision of pay rules, 2010, Rule 7 is applied by them for fixing the pay of a promotee. And Table 2, Rule 15 is applied by the said respondents for fixing the pay of a direct recruit. So that is where the discrepancy came out. When the pay was fixed for promotee in accordance with Rule 13, his pay was lower than the pay of a direct recruit.
Petition is a promotee.
Yes. And a similar dispute had arisen when the pay of trained graduate teachers was fixed by the government of Delhi after the 6th pay was implemented there, ROP 2008. And the Honorable Delhi High Court had held that the pay of a direct recruit and a promotee cannot be different. The pay of
6th pay is what? ROP?
2008, as per the central rules.
But here it's
2010. It came
2010.
2 years later. Yeah. But it is made effective from 1/1/2006. Page 31 of the writ petition.
Yes. But they have been fixed notionally.
Yes. And the actual monetary benefits are paid with effect from 1/1/2009. But the pay is fixed notionally with effect from 1/1/2006.
So as per this ROP,
Yes.
fixation of pay on promotion
Yes.
on or after 1/1/2006. 1/16 is that effective date.
Yes.
You were promoted after
I was promoted in 2008.
2008.
Yes.
So page 33, the table,
Yes.
the second chart
Yes.
provides for
Direct recruits.
4400 grade pay.
Yes.
So where is your grade pay? in respect of the petitioner.
In respect of the petitioner, Your Worship, my pay was fixed in accordance with Rule 13, promotee pay.
Rule
So-
13,
Yes,
page 32.
yes. Rule 13 is applied for fixation of pay for promotees on or after 1/1/2006. So when this Rule 13 was applied to my case, my pay was fixed at a lower level than the pay of a direct recruit.
So there's something wrong with this Rule 13.
That is why there's something wrong with Rule 13 and Rule 15, because as per the ROP 2010, the pay of a sub-inspector is the same, both for promotees and direct recruits.
So in such,
Similar,
if that's the case, are you not supposed to challenge this 13 then?
yes, but the Delhi High Court had, in fact, the same dispute had arisen before the Delhi High Court in the case of Somvir Rana. And the Delhi High Court had held that the pay of promotees should be stepped up because the pay scale is the same. Promotee and direct recruit, since the pay scale is the same, at the time of fixation of pay, there cannot be a different lower pay for promotee. So, if I may take a lordship to page 71,
Delhi High Court.
Delhi High Court. This judgment of the Delhi High Court was subsequently upheld by the Supreme Court also. In fact, the order passed by the Central Administrative Tribunal was challenged by the government of Delhi by filing a writ, which was dismissed. If I may read from...
So it originated from the tribunal?
Yes, it originated from the tribunal. The promotees had approached the tribunal and the tribunal had decided in favor of the promotees. But I'll take your lordship to the Delhi High Court ruling.
Yes.
It's quite short and it goes to the point.
Page 71.
Yes. If I may read.
Yes.
The impugned order dated 4/4/2016, passed by the principal bench of the CAT, allows the OA number 3217/2009, filed by the promotee trained graduate teachers who are the respondents before us. Respondents were promoted as trained graduate teachers before or after 1/1/2006. The question raised and answered in favor of the respondents by the tribunal relates to fixation of their pay under the CCS Revised Pay Rules 2008, rules for short, and whether there can be two pay scales for the same post of trained graduate teachers, one for promotee and other for direct recruits. The petitioners herein had applied Rule 7, which postulates multiplying the pre-revised basic pay with 1.86 factor, and Rule 13, which provides for granting one increment equal to 3% of the pay band and pay being rounded off to the next multiplier of 10. So, Your Worship, this is the rule which was applied by the state government for fixing the pay of promotees and those appointed before 1/1/2006. Rule 13 is concerning pay fixation of promotees. As far as the new direct appointees are concerned, they are given benefit of entry pay, level pay indicated in Section 2 of Part A of the first schedule of the rules. So, directly recruited officers were pay was fixed as per Section 2 of Part A of the first schedule of the rules. The entry level pay of direct appointee trained graduate teachers was higher than the pay scale of the respondents fixed under Rule 7, read with Rule 13 of the rules. This anomaly was noticed by the petitioners themselves, who had issued clarification dated 13/3/2009.
Mr. Malhotra,
Yes.
we'll pause here for a moment.
Yes, Your Honor.
Come back in 5 minutes.
I may carry on, Your Lordship.
Yes.
Para 4, page 72. This anomaly was noticed by the petitioners themselves, who had issued clarification dated 13/3/2009, which reads as under. I am directed to say that matter relating to stepping up of pay of seniors with the directly recruited juniors recruited on or Central Pay Commission was taken up with Department of Expenditure, Ministry of Finance. It has been decided that stepping up of pay of seniors will be permitted with reference to such of their, it should be adding such of their directly recruited juniors who are recruited on or after 1/1/2006 and whose basic pay is more than that of the seniors, subject to the following conditions. A. Stepping up the basic pay of seniors under the above provisions can be claimed only in the case of those cadres which have an element of direct recruitment and cases where a directly recruited junior actually drawing more basic pay than the seniors. In such cases, the basic pay of the seniors will be stepped up with reference to the basic pay of the juniors.
Just
B.
read again. Just read again. Stepping up.
Stepping up the basic pay of seniors under the above provisions can be claimed only in the case of those cadres which have an element of direct recruitment and cases where a directly recruited junior actually drawing more basic pay than seniors. So, according to this, the cadre should have both source of recruitment as promotion and direct recruitment. Only those cadres or those posts which have two sources of recruitment, promotion and direct recruitment, then the question of stepping up of the pay of seniors will arise. Stepping up the basic pay of seniors under the above provisions can be claimed only in the case of those cadres which have an element of direct recruitment and cases where a directly recruited junior actually drawing more basic pay than the seniors. In such cases, the basic pay of the seniors will be stepped up with reference to the basic pay of the juniors. Using the above provision, the government servants cannot claim stepping up their revised basic pay with reference to entry pay in the revised pay structure for direct recruits appointed on or after 1/1/2006 as laid down in Section 2 of Part A of First Schedule to the CCSR Revision of Pay Rules 2008 if their cadre does not have any element of direct recruitment or in cases where no junior is drawing basic pay higher than them. Stepping up of pay of the seniors in correspondence with the above provisions shall not be applicable in cases where direct recruits are being granted advance increments at the time of recruitment. This issues with the approval of Ministry of Finance, Department of Expenditure Implementation Cell, Government of India. The above clarification notices that pay scales at the same post in some cadres in case of promotees were lower than the pay scales applicable to direct recruits. To correct this anomaly, the clarification states that stepping up of basic pay of seniors would be permissible in the case of those cadres, number one, where appointment by way of direct recruit is permissible, and two, when direct recruited junior actually draws basic pay more than the seniors. This clarification has not been accepted by the tribunal, and in our opinion, rightly. The anomaly and discrepancy of fixing lower pay scale for promotees amounts to invidious discrimination and violates Article 14 of the Constitution. The same post with identical duties and responsibilities ex facie cannot have two different pay scales, one for the promotees and the other for direct recruits. The difficulty in accepting the plea of stepping up in terms of the clarification dated 13/3/2009 is the second condition that requires the direct recruits should have actually joined before any stepping up of pay can be granted. The date of joining would be different, as filling up of direct recruitment vacancies in the cadre would depend upon vacancy, position, selection, etc. This is unacceptable as it would be fortuitous and even whimsical. In any case, the same post cannot have two pay scales, one for the promotee and other for the direct recruit, for it violates the principle of equal pay for equal work. Stepping up of pay to be granted on satisfaction of the stipulated conditions would not rectify and undo the discrepancy and inconsistency inherent when two different pay scales are stipulated for the same post. When and this is important, Your Worship, para 7. When and after initial pay of promotee trained graduate teacher is fixed in terms of the order of the tribunal, increment would be calculated and payable as in cases covered by section 2 of part A of the first schedule of the rules as applicable to direct recruits. So stepping of pay was directed. Similar though not identical controversy had arisen before this court in WPC number 8058 of 2015, Union of India versus Malika Deb Gupta, decided on 4/11/2006. The writ petition of the Union of India was dismissed after referring to the rule position and illustrations given the rules. However, we clarified that dismissal of writ petition would not have any bearing and does not amount to acceptance of the contention raised in some of the OAs which have been disposed of by the impugned order, wherein the respondent employees had submitted that the basic revised pay should be multiplied by the factor of 1.86. For the aforesaid reasons, we do not find any merit in the writ petition and the same is dismissed. So, Your Worship, para 7. When and after initial pay of promotee trained graduate teachers fixed in terms of the order of the tribunal, increment would be calculated and payable as in cases covered by section 2 of part A of first schedule. So that is the pay fixation of direct recruits. And in pursuance to this, Your Worship, the Union of India, Government of India, Government of New Delhi had filed an appeal before the Supreme Court, which was dismissed. The order is at page 76. If I may read from page 77.
Yes.
Delay condoned. We find that there are several matters in which the aggrieved employees have been going to the tribunal, then to the High Court, and thereafter those matters are brought before this court at the instance of the Union of India / NCT of Delhi. Once the question in principle has been settled, it is only appropriate on the part of the Government of India to issue a circular so that it will save the time of the court and the administrative departments, apart from avoiding unnecessary and avoidable expenditure. The present situation is that the stepping up is available only to those who have approached the court. But since the issue has otherwise become final, we direct the Government of India to immediately look into the matter and issue appropriate orders for granting the pay scale so that people need not unnecessarily travel either to the tribunal or the High Court or this court. With the above observation direction, the special lead petitions are dismissed. So, and Your page 78 is the office memorandum issued by the Government of India in pursuance of the directions of the Honorable Supreme Court. If I read this office memorandum, Your Worship, I think things will be much more clearer also.
Yes.
Page 78, Office Memorandum dated 28 September 2018. The undersigned is directed to invite the attention to the provisions contained in Section 2 of Part A of First Schedule of the Central Civil Service Revised Pay Rules 2008, which provides for entry pay in the revised pay structure with effective from 1/1/2006 up to 31/12/2015 for direct recruits appointed on or after 1/1/2006 on a post, and to say that pay in respect of persons appointed to the same post before 1/1/2006 is required to be fixed as on 1/1/2006 under Rule 7, Subclause 1, Subclause A, Subclause I, and pay in respect of persons appointed on the same post on promotion on or after 1/1/2006 is required to be fixed under Rule 13 thereof. So, Your Worship, those who are appointed directly to the post, their pay has to be fixed under Section 2 of Part A of First Schedule of the Pay Rules of 2008. Whereas those who are appointed before 1/1/2006 is required to be fixed under Rule 7, and those who are promoted on or after 1/1/2006 is required to be fixed under Rule 13. A number of references were received in the Ministry of Finance Department of Expenditure stating that the pay of seniors of a post was fixed at a stage lower than the entry pay applicable to the persons appointed on direct recruitment basis on that post on or after 1/1/2006. In such cases, stepping up of pay was allowed to the senior employee at par with the entry pay of direct recruits of those posts, subject to the conditions inter alia that stepping up of pay of seniors is applicable only in those cases which have an element of direct recruitment and where a directly recruited junior is actually drawing more basic pay than the seniors. Thus, the stepping up of pay of senior employees was admissible from the date a junior direct recruit joined on or after 1/1/2006. The matter was also considered in the meeting of National Anomaly Committee held on 17/7/2012. Based on a demand raised by the staff side under the JCM, NAC had recommended that in cases where recruitment rules provide for direct recruitment, then the stepping up of pay of senior may be considered, even if no actual direct recruitment takes place or no direct recruit has actually joined. However, it was decided that stepping up of the pay of seniors can be claimed only in case of those cadres which have an element of direct recruitment and in cases where a directly recruited junior is actually drawing more basic pay than the seniors. Thus, stepping up of pay was dependent upon actual joining of a direct recruit. Trained graduate teachers of the Government of National Capital Territories of Delhi filed an OA number 3217/2014 before the Honorable Principal Bench of CAT. The 13 petitioners of the post of trained graduate teachers comprised those who were appointed as TGT before 1/1/2006, as also those who were promoted to the post of TGT on or after 1/1/2006. The pay of these 13 employees has been fixed as per the relevant provisions of the CCS RP Rules 2008, and the same happened to be lower than the entry pay as applicable to direct recruits of the post of TGT appointed on or after 1/1/2006. These petitioners prayed for refixing their pay as applicable to direct recruits appointed on or after 1/1/2006. The Honorable Principal Bench of CAT, in their order dated 4/4/2016, in OA number 3217/2014, allowed the application and directed the government to ensure that none of the applicants' pay is fixed at a stage lower than the pay, which could be drawn by a direct recruit appointed on or after 1/1/2006. The order of the Honorable CAT dated 4/4/2016 was upheld by the Honorable Delhi High Court in terms of the order dated 23/3/2017 in WPC number 2634/2017. The Honorable Delhi High Court, in its order dated 23/3/2017, observed inter alia that the plea of stepping up of pay, as mentioned in para 2 above, means that the direct recruit should have actually joined before any stepping up of pay can be granted, and the date of joining would be different, as filling up of direct recruit vacancies in the cadre would depend upon vacancy, position, selection, etc. The Honorable Delhi High Court held that this was unacceptable. The matter arising out of the aforesaid order of Honorable Delhi High Court dated 23/3/2017 was heard by the Honorable Supreme Court as part of SLP, and in its order dated 1/9/2017, diary number 23663/2017, the Honorable Supreme Court has observed that once the question in principle has been settled, it is only appropriate on the part of the government to issue a circular. The Honorable Supreme Court further observed that the present situation is that the stepping up is available only to those who have approached the court. But since the issue otherwise became final, the Honorable Supreme Court directed the government to immediately look into the matter and issue appropriate orders. Accordingly, the matter has been considered in the light of the above background and in the context of the specific orders of the Honorable Supreme Court dated 1/9/2017, as arising out of the original issue raised by the trained graduate teachers of GNC-TD in terms of the OA number 3217/2014. As mentioned above, the petitioners in that case were those who were appointed as TGT before 1/1/2006 and also promoted as TGT on or after 1/1/2006 and had occasion for grievance because their pay in the pay structure in vogue from 1/1/2006 has been fixed lower than the entry pay as prescribed for direct recruits appointed as TGT on or after 1/1/2006. Therefore, the principle of the benefit of pay fixation, as flowing from the aforesaid orders of the Honorable CAT, Honorable Delhi High Court, and the Honorable Supreme Court, is that the pay of those who were appointed to the post prior to 1/1/2006 and those who were appointed to the post on promotion in the pay structure effective from 1/1/2006 onwards, and where in respect of such posts, entry pay for direct recruits appointed on or after 1/1/2006 has been prescribed, giving rise to differential pay may not be lower than the set entry pay. It is the case of differential pay in respect of employees of a post as caused by the existence of entry pay applicable for direct recruits on that post, appointed on or after 1/1/2006, that has been addressed in the aforesaid case of the post of TGTs. In case entry pay as per Section 2 of Part A of the first schedule of the CCS RP Rules 2008 is not applicable in case of a post, the same will not give rise to differential pay for holders of the post, and hence not covered under the ratio of the case of TGT. Accordingly, the President is pleased to decide that in respect of those posts where entry pay for direct recruits appointed on or after 1/1/2006, as per Section 2 of Part A of the first schedule of CCS RP Rules 2008, becomes applicable by virtue of the provision of element of direct recruitment in the relevant recruitment rules. The pay of central government employees who were appointed to such posts prior to 1/1/2006 and who was pay as fixed in the revised pay structure under Rule 7 thereof, as on 1/1/2006, turns out to be lower than the prescribed entry pay for direct recruits of the post, shall not be less than such entry pay with effect from 1/1/2006. Likewise, the pay of central government employees who were appointed to such posts by way of promotion on or after 1/1/2006 and whose pay, as fixed under Rule 13 of the CCS RP Rules 2008, happens to be lower than the set entry pay, shall also not be less than such entry pay from the date of their promotion taking place on or after 1/1/2006. So,
Mr. Malhotra,
yes,
so the matter pertains to the Sixth Pay Commission.
yes,
Sixth pay, isn't it?
Sixth.
Although it was implemented 2 years later in the state of Mizoram,
Mizoram.
but the effective date has been made as 1/1/2006.
Six.
Notional benefit will be given, but the actual benefit given from a subsequent date.
Yes, 1/1/2008.
Now, the question here is, if there's a post
Yes,
which is to be filled up by way of promotion and by way of direct recruitment,
yes,
taking the date of 1/1/2006.
yes,
Many employees were appointed before 1/1/2006, and in the same post, another set of employees were employed after 1/1/2006.
yes,
It so happened that those who were already employed on their promotion, if their grade pay is lower,
if the pay is lower,
if their pay is lower,
pay fixation is lower.
pay fixation is lower than those directly appointed after on 1/1/6 or 2006, it should be stepped up
Yes.
at the same level.
Yes.
This is the main idea behind. This is the main idea behind.
And in this case also, Your Worship, the pay of sub-inspector under the ROP 2010 for direct recruits is under Table 2 of Rule 15. And the pay of promotees is under Rule 13. So when the pay was fixed under these two provisions, the pay of the promotee was fixed at a lower level than the pay of a direct recruit.
Now, what does the record say? Is it just a case in respect of the petitioner, or similar situation has arisen in others?
Yes.
What do they say?
In fact, it is not only the case of the petitioner. His seniors were also, who were subsequently appointed to the post of inspector. So when they were promoted to sub-inspector, their pay was fixed as per Table 2, Rule 15, by the DDA. But then when they were promoted to the post of inspector, then at the time of fixation of pay, the respondent said, no, your pay should have been fixed as per Rule 13 and not Table 2 of Rule 15. So that is why their pay was fixed again and the basic pay was lowered. If your lordship will see,
Your case is a case of stepping up or stepping down?
now it is a case of because of the interpretation made by the DDA, my pay was, although it should have been fixed as per Rule 13, because I'm a promotee, but the DDA had fixed my pay as per Table 2, Rule 15.
Let us see that rule. Where is that? Page 31 onwards, isn't it?
Yes. Rule 13 talks about fixation of pay on promotion after 1/1/2006.
Oh, no, after 1/1/2006.
So my
This is common for everyone?
yes.
For promotees and for direct recruits also?
No, this is for promotees.
This is for promotees.
So my pay should have been fixed as per Rule 13 when I was promoted to the post of sub-inspector in 2008. But my pay was fixed as per Rule 15, Table 2, which is at page 33. That is the pay to be, that is the pay for direct recruits.
Correct.
So
So you were enjoying higher pay?
yes, throughout. But when I was promoted to the post of inspector, they refixed my pay and they reduced it. If your lordship will see page 35. Page 35, your lordship.
Yes.
This is my last pay certificate as a sub-inspector. Just before I was, before my pay was fixed on promotion to inspector. If your lordship will see, my basic pay, serial number 1, column 3 is 57,400. Has your lordship got it? Last pay certificate of SI Rauchara Sangte.
Correct. So the next page is 55,200.
Yes.
There's a difference.
So now this is the pay fixed by the respondents after my promotion to inspector. My basic pay has been reduced.
So is it not a case, Mr. Malhotra, that
Yes.
while you were promoted to the post of SI,
Yes.
what was to be applied was
Rule 13.
Rule 13.
Yes.
Instead, they applied Rule
15, Table 2.
15,
Table 2.
Table 2.
Yes.
So now realizing this mistake, now
They tried to correct it
they have corrected.
in 2022. So, but now what I've stated is that the correction made by them is illegal. Because if we go according to the judgment of the Delhi High Court, which was upheld by the Supreme Court, when the pay scale of the post is the same, they cannot be two different pay fixed for a direct recruit and a promotee.
So
That is why
you show me where is the pay scale of the direct in the post of inspector?
that is at your worship will see table 2 rule 15, page 33.
No, what is the actual conversion now?
So, Your Worship, so the entry pay for direct recruits as per Rule 15, Table 2 is, like we said, grade pay 4,400, pay in the band is 10,520, and the pay is 14,920.
Now you come to page 36.
Yes.
This is a payslip of 2022.
Yes.
What is the standard conversion? Or what is the pay given to a direct recruit in the post of inspector?
Your Worship, this, I think that will be as per page 33. But now because of all the increments, because this was the pay fixed in 2008.
See, Mr. Malhotra, it's important that the
Yes.
court understands it. Number one is that 2006 ROP provides for certain pay.
Yes.
It also provides that if there's two sources of recruitment, one is by promotion, one is by direct, taking the date of 1/1/2006, those who had promoted earlier, those who were in service earlier on promotion, if their salary is lesser than the basic pay, is it?
Yes.
The basic pay.
Yes.
What is the terminology? Basic pay.
The pay of the direct recruits. Entry pay.
What does it say?
Page 33, it says entry pay.
Pay scale. Delhi High Court has said pay scale.
Pay scale.
So if the pay scale is lower than what is given to a direct recruit, it should be upgraded,
Stepped up.
stepped up.
Yes.
Now, in your case, you were promoted to sub-inspector.
Initially, it was stepped up. Then, when I was promoted to inspector, they said that no, it's been done illegally. Then they sort of
No, the initial,
refixed it at a lower scale,
no, that's what. The step up was incorrectly done.
according to them. But according to my submission, it is correctly done.
What should be applicable? 13 or 15?
According to me, Your Worship, the Table 2, Rule 15 was correctly applied in my case because of the judgment of the Honorable Delhi High Court. But they have said that no, it should be fixed as per Rule 13. So that is where the dispute lies.
Okay, that is in the post of sub-inspector.
Yes.
In the post of sub-inspector, 15 was correctly applied according to you.
According to me.
Then once you go from the sub-inspector post to the post of inspector,
Yes.
what should be applied? If you're already getting the pay scale
Yes.
equivalent or more than what a direct recruit gets, then the conversion will be 13.
No, Your Worship, the additional affidavit, Your Worship,
When were you promoted to the post of SI?
2008.
2008.
Yes.
So
So when I was promoted in 2008, Your Worship, when the time came, I was promoted in September 2008. So when the time came for fixation of my pay on promotion, if I may take Your Worship to para 6, this will clarify
para 6 of?
the writ petition.
Okay. Para 6.
That when the pay of the petitioner was fixed by the respondents on his promotion to the rank of sub-inspector on 26/9/2008, as per Rule 13 of the 2010 rules, his pay as compared to the pay of a directly recruited sub-inspector fixed as per Table 2 of Rule 15 of the 2010 rules was much lower. Due to this, the then DDA in the police headquarters, in consultation with respondent number 5, had fixed the pay band of the petitioner in PB2 9,300-34,800 by fixing his pay as GP 4,400 plus 10,520, amounting to 14,920 in accordance with Table 2. So
your pay scale was lower.
because when they had fixed my pay as per Rule 13 of the 2008 rules,
It was lower.
it was lower than the pay of a direct recruit as per Table 2 of Rule 15.
So Rule 15 was applied.
Rule 15 was applied. And it carried on from 2008 to 2022. Only when I was promoted to the post of inspector in 2022, when my first pay slip was issued in 2022, an extra 4, then they made the correction.
How was the correction done?
By,
By applying
by applying Rule 13.
13.
Yes. So
Now, see, now the question is, what is the pay scale of the direct recruit in the post of inspector? Is it higher or lower to your scale?
no, Your Lordship, the pay scale is the same. If Your Lordship will see the additional affidavit, para 2. There's no, it's only when the fixation of pay is done as per the rules, then different pay comes in, but the pay scale is the same. If Your Lordship will kindly see additional affidavit, para 2.
Yes.
That the answering deponent, in compliance of this Honorable Court's order dated 24 May 2024, submits that there are no separate pay band of direct recruit and pay band of promotee in the post of Sub-Inspector of Police in the Mizoram Revision of Pay Rules 2010, notified wide number dated 6/8/2010, wherein the pay band of Sub-Inspector and Inspector of Police may be seen at serial number 478 and 480, page 27, Your Lordship. So, Your Lordship will see serial number 478, the pay of a sub-inspector as per the ROP 2010 is PB2, 9,300-34,800, grade pay is 4,000. So, the pay, irrespective of the sub-inspector being a promoter or direct recruit, his pay is the same. But the problem arose when the pay fixation was done as per Rule 13 and Table 2, Rule 15. Rule 13 for promotees, Table 2, Rule 15 for direct recruits.
In the post of SI.
SI.
Since it was lower,
Yes.
so it was stepped up.
Yes. So now, but then from 2008 to 2022, there was no problem. But when I was promoted to the post of sub-inspector, then the respondent said that no, the stepping up of pay was illegal. It should be your pay should have been fixed as Rule 13. So that is why my pay was reduced, basic pay.
Stepping up was done on which year?
2008, September.
2008. Realization came in 2022.
Yes. If Your Lordship will see para 7.
Of the additional affidavit?
No, of the writ petition.
Yes, para 7.
So that we have given a chart how the pay of the petitioner was fixed from the date of his promotion to the rank of SI, sub-inspector on 26/9/2008, till the date of his promotion.
1722.
Yes, 9/5/2022. Yes. So on 26/9/2008, when he was promoted, they had fixed his pay by applying Table 2, Rule 15. Then it continued like that. I kept getting my increments and everything. Then in 2022, when I was promoted to the post of inspector, then they suddenly said that no, your pay should have been fixed as Rule 13. And they lowered my pay, basic pay.
What do they say in the affidavit? Counter affidavit.
Yes, ma'am. Para 4, Your Honor. That is the reply to para 6. If I may read para 4 here.
I've read it. See, they say that it's not correct. Since you are a promotee, the Table 2, Rule 15 is not correct.
Yes. It should be Rule 13.
It should be Rule 13. But then what about your pay scale being lower than the direct recruit? Supposing your pay scale was lower than the direct recruit, then should it not be stepped up?
That is what, Your Worship, that is what I'm trying to say, that, Your Worship, that it was correctly stepped up by them in 2008.
There are two methods. One is that Rule 13,
Rule 13 for promotees.
promotees, and Rule 15 for direct.
Direct.
They gave a Rule 15
Yes.
when you were promoted in SI.
Yes.
Later on, realizing that you should not have been given,
Yes.
you should have been given under Rule 13. Your pay has been accordingly refixed.
But my humble submission, Your Worship, is that they have done it correctly. Because the Supreme Court as well as the High Court has held that when the pay of the direct recruit is higher than the pay of the promotee senior, then his pay should be stepped up.
What do they say on that?
They say that the office memorandum, which was issued by the Union of India, which is at page 78, Your Worship, as per the directions of the Honorable High Court of Delhi and Supreme Court, they say that it has not been the exact words.
They have not adopted.
They have not adopted.
This is in the affidavit of position.
Yes, that is the specific term used by them. It has not been adopted by them. My humble submission, Your Worship, is that
Is it to be adopted specifically?
even if it is not adopted by them, Your Worship, but the law laid down by the Honorable High Court as well as Delhi, the Supreme Court, that there cannot be two different pay for a direct recruit and a promotee in the same post. That is the principle which has to be followed.
See, that having two different pay, that is another thing.
Yes.
Firstly, what was regarding the step up, whether it was rightly stepped up or not?
Yes.
You say it was rightly stepped up.
was
They
right.
say it was wrongly
Wrong.
stepped up. That is one issue. The other issue is whether there can be two pay scale.
Yeah.
How do you say that there's two pay scale? That's why I asked you, what is the pay scale of the direct recruit?
Your Worship, there's only one pay scale for the post of sub-inspector. Now, the pay fixation, when the pay is fixed for promotee, it is fixed under Rule 13. When the pay is fixed for direct recruit, it is fixed under Table 2, Rule 15. And when those rules are applied, then the difference in the pay comes in. Otherwise, the pay scale is the same. The pay scale, as per the additional affidavit, is the same.
So there's something wrong with this rule then.
Because additional affidavit, page 27,
Why should there be two criteria for promotion?
that is why, Your Worship, even in the case of the trained graduate teachers, the pay of the promotee was fixed under Rule 13. The pay of a direct recruit was fixed under Section 2. Page 72, Your Worship, the judgment of the Delhi High Court.
See, that takes us back to the same old question regarding this notification of 6 August 2010. You're not challenging this?
I'm not challenging this because, Your Worship, the reason I'm not challenging this because as per their own additional affidavit, the pay of the sub-inspector is the same for direct recruits, for promotees. But it is only at the time of pay fixation, the anomaly comes in. So that is why I'm referring to the judgment of the Delhi High Court in Sombir Rana, where when the pay fixation is done, and if the pay of a promotee is lesser than the pay of a direct recruit, then the pay of the promotee has to be stepped up.
Normally it happens the other way around, isn't it?
Yes.
Direct means
Yes.
fresh candidate coming for the first time. He will enjoy what is the pay scale, that's all.
Yes.
But a promotee who has been in service from the lower ranks,
He may have got some
he'll
increments.
be having all those increments. His pay will be much higher.
Yes.
But this is a clause for protection of the promotee.
Yes.
In view of him or her rendering many years of service on promotion, if he still gets lower than the new entrant, his pay should be stepped up.
Stepped up.
That is the protection given.
Because if
Perhaps.
your Lordship will kindly go to page 72 of the judgment of the Delhi High Court. Para 2, you also will see, the petitioners, that is the Union of India, had applied Rule 7. Rule 7 is for fixation of pay of the promotee. which postulates multiplying the pre-revised basic pay with 1.86 factor.
Rule 7 means,
Rule 7 of the CCS ROP rules 2008.
do we have it here?
I think we have it.
This page 31 is a ROP rules.
That is 2000, the Mizoram pay rules.
This rule 7 is from which rule?
2008 rules.
Is it similar to with rule 2010?
Yes, Your Honor.
Rule 7.
Rule 13 is similar. Rule 13 is for promotion. Sorry. If your lordship will see Rule 13.
When you were promoted to SI,
Yes.
it was lower, and therefore some advice was sought from the
Para 6, Your Honor,
para 6 of the writ petition.
of the writ petition.
What do they say to that?
Yeah. Subsequently, it was not approved.
It was not approved.
Later,
by-
not approved. At the relevant time, it was approved. Later on, after 2008, 18, after 14 years, it was not approved.
So, by saying that, does it mean that they also admit that it was lower?
Yes,
That is why it had to be stepped up.
it had to be stepped up.
It was later not approved is a different thing. Whether it was equal or not, whether it was lower or higher, they have not said anything. Your specific allegation is that since it was lower,
Yes,
it was stepped up.
yes.
In consultation with respondent number 5. Who is respondent number 5?
Respondent number 5, Your Lordship, is
Finance
the Chief Controller of Accounts.
Chief Control. Second table, Rule 15 was correctly applied.
According to me.
That's your case.
That's my case.
But now in 2022, what do they apply? Rule 13.
Rule 13. If your lordship will see the representation which I had submitted, the reply given to me, which is at page 41.
Now, why do they apply Rule 13?
Rule 13, your lordship, they have applied it because it is the rule which sort of gives the formula for fixation of pay on promotion on or after 1/1/2006.
But if you compare it with the direct recruit, if it's still lower,
Yes,
then it has to be stepped up.
it has to be stepped up. So the action taken by them at the time of fixing my pay, when I was promoted to SI in 2008, my submission, your lordship, is that there is nothing illegal about it. Then 14 years after everything has been done, then they come up with the plan that it was done illegally.
If you stick to that pay, LPC,
Yes.
the basic pay of 57,400
Yes.
compared to the refixation of 55,200,
Yes. Yeah.
are you getting anything in excess or anything more than the other direct appointees in the post of inspector? Because the basic aim is to bring you to that level.
To that level.
If you exceed, there's no such provision to bring you down.
Yes.
Like I said, in respect of in-service employees, all these years they earn increments.
Then-
Ultimately, compared to the direct recruits, they
Pay should be
emoluments are
higher.
much higher.
Yes. For 14,
But that the ROP, the fifth pay or sixth pay? Fifth pay.
Sixth pay.
Sixth pay had revised the pay of all the concerned.
yes,
So amount was much higher
much higher.
than the previous fifth pay,
Fifth pay.
naturally.
Yes.
So that being the position, when the process of fixation of the salary comes,
Yes.
if it so happens that a promotee gets lesser than the direct recruit in the entry grade of the direct recruit, it should be stepped up.
It should be stepped.
That protection was given.
That, in fact, if Lordship will kindly see para 7 of the
It
judgment.
doesn't
of the,
operate in the reverse order, isn't it?
No.
That if it's too high, you bring him down.
And if your Lordship will see page 74, the direction of the Honorable Delhi High Court.
Yes,
Para 7.
yes.
When and after initial pay of promotee, trained graduate teacher is fixed in terms of the order of the tribunal, increment would be calculated and payable as in cases covered by section 2 of part A of the first schedule of the rules, applicable to direct recruits. So this is a case of stepping up. So the High Court had directed that the promotee trained graduate teacher pay should be stepped up so that it is equal to the pay of a direct recruit fixed as per section 2 of part A of the first schedule. So it's a case of stepping up. Because the Honorable High Court had held that it's a clear violation of Article 14 if there are two different pay scales for the same post. One for direct recruits and one for promotees.
What does it mean, this paragraph 2? Paragraph 7?
It means that the respondents herein had approached the tribunal, the CAT, and the CAT had allowed their petition, saying that their pay should be stepped up. If your Lordship will allow me.
You come to page 69,
Yes, you are-
paragraph 12.
Par-
They should ensure that none of the appellant's pay is fixed at the stage lower than the pay which could be drawn by a direct recruit appointee on or after 1/1/2006. So promotees cannot be given lower pay than the direct recruit.
direct recruits.
Which direct recruit were appointed on or
After
after
1/1,
1/1/2006. So now 7, when and after initial pay of promotee trained graduate teacher is fixed in terms of the orders of tribunal, increment would be calculated and payable as in cases covered by section 2 part of part A. Where do you get this section 2 of part A?
That will be in the ROP 2008.
This is the Mizoram ROP 2010.
No, the central.
Schedule. First schedule.
Your Lordship, I think this will clarify it. If Your Lordship will see, kindly see para 7 again.
Of?
The judgment, page 74.
That's what, see, I was just trying to find out section 2, part A of the first schedule. Where's the first schedule? Okay, first schedule, section 2, part A. Yes, that is the one which you have highlighted in your, you have extracted this in your writ petition also.
But in our writ petition is table 2 of rule 15. So it is relatable to,
I think this is similar.
yes.
Use a paragraph.
Paragraph 5. Page 5. Page 5 and 6. Section 2, part A of first schedule is comparable to table 2, rule 15, I think.
Nine three 34,800. Okay. Increment would be calculated and payable as in cases covered by section 2, part A of the first schedule of the rules as applicable to the direct recruits. Similar, though no identical controversy had arisen before this court. Anyway, we come back to
Yes, sir.
I would like to seek Lordship's indulgence in making a mention for this item number 14 of today's list for the hearing. Lordship, since this present matter is going to take some time and there's also one hearing matter fixed as item 13, if this matter may be kindly passed over for the day for tomorrow, Lordship, if possible.
For tomorrow.
It's a short matter, but otherwise, my lord. It's arising out of an eviction suit.
Just for the other side, Mr. Bidurao. Okay. Let's wait for where the parties list the matter again tomorrow.
I'm deeply obliged.
Much obliged.
Item 14. Yes, where were we?
Yes.
Mr. Malhotra.
May it please Your Worship, yes. So the controversy in the present case, Your Worship, is arising out of the application of Rule 13 in the case of promotees and Table 2 of Rule 15 in case of direct recruits. Even though the pay scale of the post of sub-inspector is the same, both for promotees and direct recruits. There's only one pay scale under the CCS ROP 2010. But then at the time of fixation of pay, under Rule 13 and Table 2, Rule 15, a difference in the pay arises, whereby the pay of the promotee is lower than the pay of the direct recruit. So that is why, Your Worship, when I was promoted to the post of sub-inspector, the respondents themselves had fixed the pay of the petitioner as per Table 2, Rule 15. And then after 14 years, in 2022, when I was promoted to the post of inspector, they refixed my pay as per Rule 13. And due to which my basic pay was also lower. So that is the action which has been challenged by the petitioner. And in between, the representations were also rejected.
According to you, what should have been done in 2022?
In 2022, Your Worship, since the law is clear that the pay of a promotee and the direct recruit has to be similar, and the pay of a senior cannot be lower than the pay of a junior, then by applying FR 22, the pay should have been stepped up, which was correctly done in my case.
No. Stepped up already happened in,
Yes.
in the post of SI.
Yes.
Now, when you were further promoted to inspector, then
Your Worship,
what would be the pay for inspector?
That is, Your Worship, in the additional affidavit it is given.
Again, that exercise has to be undertaken. Either Rule 15 or Rule 13.
Your Worship, they should have, the respondents should not have corrected my basic pay. If Your Lordship will see, Annexure 3.
That is why I was asking you, what is the pay of inspector?
They should have, page 35, my basic pay in May 2022, before my promotion to inspector as SI was 57,400. So on this basis, they should have fixed my pay as inspector.
What is the basic pay of inspector?
Basic pay of inspector, Your Worship, will
Is it higher than 57,400 or lower than 57,400?
If Your Lordship will see the affidavit, additional
I don't know
affidavit-
whether you've understood my question.
I
or not.
understand, Your Honor.
Because once it was already fixed as per that ROP rules when you were promoted to SI, does one have to again refix as per the ROP when you are promoted to the post of inspector?
It'll be much higher. If Your Lordship will kindly see page 30, my promotion order.
Inspector.
Yes, Your Honor. Page 30, this is the typed copy of the promotion order. The original is at page 29. if I may read, Your Worship, in the interest of public service and in pursuance of the recommendation of the Mizoram Police Service Commission, white letter dated, it should be, sorry, Mizoram Public Service Commission, white letter dated 22/5/2022 and conveyed by Home Department, white letter dated 5/5/2022, the following sub-inspectors of police, Arm Branch, are hereby promoted to the rank of Inspector of Police, Arm Branch, in the level 8 of the pay matrix, 44,900 to 99,800, 7th Central Revision of Pay, as modified and extended to the employees under the Government of Mizoram Rules 2018. So by this time, Your Worship, the 7th pay had already been adopted.
Correct. So what is then you come to page 36. This is your pay slip.
Yes.
How do we understand this breakup? Pay matrix in one hand
Yes.
and the basic pay and the other, like great pay and all that.
But if I may take your lordship to the annexure 6, page 41. This is the reply given by the respondents against my representation for protection of pay. If I may read, Your Honor. This is dated 17th of, in fact, Your Honor, I was anticipating this problem. And before my promotion also, I had already submitted my representation. And this was the reply given to me. I am directed to inform you that State Government of Mizoram has not adopted Government of India OM dated 28/9/2018, issued by the Department of Expenditure, Ministry of Finance, since it entails additional expenditure and it can also entail modification of many past cases of pay fixation and pension calculation, and hence pay fixed as Rule 13 of ROP 2010 will stand. So they were adamant that my pay has to be fixed as per Rule 13.
So even before filing of the writ petition also, they have said that they have not adopted this
Yes.
OM. Refixation was done, but there's no such kind of move on their part to ask for a refund,
No,
deduction.
that was not done. But that also, Your Worship, the refund, even if they had directed the petitioner to make a refund, since he had enjoyed the higher pay scale for more than 5 years, without any false misrepresentation from his side, that famous,
Cannot be recovered.
yes, it cannot be directed to be refunded. Your Worship, in my case, the only difference with the Delhi High Court judgment is that in that case, since they were not given the higher pay, they had approached the tribunal as well as the High Court for higher pay, which was given to the direct recruits. In my case, the respondents themselves had given me the higher pay given to direct recruits for more than 14 years. And then when I was promoted to the post of inspector, then they refixed my pay as per Rule 13.
So, undisputed position when you were promoted to SI
Yes.
was that your basic pay was lesser than a direct recruit. So, with the permission or with the clarification from the respondent number 5, you were given that.
Yes.
Now, 14 years down the line, they say that finance did not approve it.
Yes.
And you had been wrongly given the conversion as per
Table 2, Rule
Table
15.
2, Rule 15. Besides, OM 28/9/2018 is not adopted by the state. So you cannot claim that benefit. So it may not be an isolated case, isn't it? Ultimately.
Ultimately, yes, Your Worship, there'll be
many
sub-inspectors whose pay was again lowered after their promotion to inspector.
Seeing your promotion order, and at the same time your pay slip.
Yes, sir.
Promotion order talks about pay matrix. Pay slip talks about the basic and emoluments.
Yes, sir. Page 36, my basic pay was fixed at 55,200. Whereas even in my last pay slip as per SI, sub-inspector, my basic pay was already 57,400.
How much is the difference? 2,200.
Yes, sir.
Yes, so that's your case.
Yes, sir. And Your Worship, so para 9 of my writ petition. If I may. However, after promotion of the petitioner to the rank of inspector on 9/5/2022, the respondents have illegally refixed the basic pay of the petitioner. And as per payslip dated 19/8/2022, the basic pay of the petitioner as on 31/5/2022 has been reduced to 55,200 per month. And in their reply at para 7 of the affidavit filed by them,
Yes. Clarification of the finance.
yes.
9.3.
And next page, incorrect pay needs to be rectified because the petitioner is not a direct recruit, but a promotee. And hence, entry pay of direct recruits is not applicable to him. So that is the main reason.
The stepping up of pay is provided by the judgment of the tribunal,
Yes,
not by the ROP, isn't it?
not by the ROP.
ROP merely says para 12 and para 13 and para 15.
Para 13 and para 15. And in the ROP 2008 central pay rules, it is Rule 13 and section Section 2 of Part A of the first schedule.
Section 2,
Section 2 of Part A of the first schedule. Yeah, I think it is at page, relevant portion is at page 43 here.
which is the chart which is relevant to you?
Your Worship,
93,
PB,
PB2.
PB2, 9. But Your Worship, the difference in this ROP 2008 central pay rules and ROP 2010 Mizoram revision of pay rules, if Your Lordship will see, one grade pay has been inserted by the government of Mizoram.
One more grade pay.
Yes. At page 33 of the writ petition. Is Your Lordship?
Yes, what is that?
4,200, then 4,400. Grade pay. Then 4,600, then 4,800. But in the central pay rules, 2008, this grade pay of 4,400 is not there. That is the only difference. The state respondents have added one grade pay, 4,400. That is the only difference.
But it is a accepted position in law that this kind of pay revision are adopted by the state,
Yes.
and in certain cases in a modified form.
In a modified form. They had revised it a bit. The state government, while applying the 2008 central pay rules, had inserted a few clauses of their own.
So the insertion is the benefit which was given to you,
Yes,
perhaps?
yes,
4,400.
yes, 4,400. Great pay.
Where is your promotion order? To SI. Have you annexed that SI promotion order?
No, Your Worship, I have not annexed. if we go through the judgment of the Central Administrative Tribunal, Your Worship, it appears that the direct recruits' pay was at a higher level because they were given some advance increments. That is why there was a difference in the pay of a direct recruit and a promotee. And
From the judgment of the tribunal.
from the judgment of the tribunal. If I may take your Lordship to page 68, the relevant operative portion of the judgment of the tribunal, para 11.
Yes.
If I may read para 11. As regards OA number 2835 2011 with OA 2842 2011 and 2843 2011 concerned, these were filed by PSTs, TGTs, and PGTs. The substantive question before the tribunal was whether the direct recruits who have been appointed prior to 1/1/2006 can be placed at a lower pay scale than those direct recruits who were appointed after 1/1/2006. Page 68, Your Worship.
This is a judgment of tribunal.
Central Administrative Tribunal. Principal bench.
So the tribunal is referring about another order by the tribunal.
Yes.
What was the other case?
That was a case where, that if we read para 11, that was a case which was filed by those TGTs who were appointed prior to 1/1/2006 and whose pay was lower than the direct TGTs who were appointed on or after 1/1/2006. But the same principle was applied. The tribunal concluded that the respondents should ensure that the pay of no incumbent of the posts of PST, TGT, and PGT appointed prior to 1/1/2006 is fixed lower than the pay which could be drawn by the fresh appointee of the post as on 1/1/2006. The crucial clarification based on which the respondents have rejected the claim of the applicants seems to be the clarification dated 5/5/2010, which has simply quoted the DOPT clarification dated 27/2/2009, which is the same as the clarification issued by the MHRD dated 13/3/2009. As per this clarification, stepping up of basic pay of seniors can be claimed in case of those cadres which have an element of direct recruitment and in cases where directly recruited juniors are drawing more basic pay than the seniors. However, as stipulated in Part C, Subpara C of Circular dated 13/3/2009, stepping up of pay shall not be applicable in cases where direct recruits have been granted advance increment. The respondents do not deny that there is an element of direct recruitment in the teacher cadres, that is PST, TGT, and PGT. Therefore, this circular squarely applies, which is also acknowledged by the respondents in their speaking order dated 2/8/2014. It is also not denied that juniors are drawing basic pay more than the seniors. Therefore, by a plain reading of these instructions, it is clear that pay of the applicants would need to be stepped up to the level drawn by direct recruit juniors who are appointed on or after 1/1/2006. The respondents' argument, though not very clearly spelled out either in their reply or in the order dated 2/8/2014, seems to be that direct recruits appointed on or after 1/1/2006 are granted advance increments at the time of recruitment, and hence benefit of stepping up of pay is not available in such cases according to clause C quoted above. This leads to an absurd situation that a senior on pay fixation under FR 22C draws lower pay than his junior. It is precisely for this reason that in OA 2835/2011 with OA 2842/2011 and 2843/2011, this tribunal has held that pay of incumbents appointed/promoted prior to 1/1/2006 should not be lower than the pay which will be drawn by a fresh appointee on or after 1/1/2006. In view of the above, the OA clearly succeeds and the order dated 2/8/2014 set aside with a direction to the respondents to refix the pay of the applicants as per 6 CPC recommendations. They should ensure that none of the applicants' pay is fixed at a stage lower than the pay which could be drawn by a direct recruit appointee on or after 1/1/2006. Time frame of 2 months is fixed for implementation of this order. So the pay of the direct recruits was fixed at a higher level because of some advance increments which was given to them. It appears from this order. So basically, Your Worship, the decision was to step up the pay of the promotees so that their pay is equivalent to the pay of direct recruits who are junior to them, which in my case was already done at the time of my promotion to sub-inspector. But then 14 years down the line, when I was promoted to the post of inspector, they have again taken away that pay scale, pay fixation, which was given to me, by saying that your pay has to be fixed as per Rule 13. That is the main thing. And even the High Court has held that such action is in violation of Article 14. Para 6 of the judgment of the High Court, Your Worship, page 73.
So, minus the judgment of the tribunal, High Court and the Supreme Court,
Yes.
what remains is the ROP rules. 2008, in case of the central government, in 2010 in case of the state government.
State government. And the additional affidavit filed by the state clearly shows that the pay scale of a sub-inspector is only one. There is no different pay scale for a direct recruit a sub-inspector or a promotee sub-inspector. There's only one pay scale. And one last point which we have raised is that the pay could not have been refixed after 14 years without issuing a show cause notice also. Principles of natural justice were blatantly violated. 14 years down the line, they have refixed my pay to a lower level without even issuing a show cause notice. That is one additional point, Your Worship. In para 29 of the writ petition. Para 29. You know. Action of the respondents in reducing the basic pay of the petitioner from rupees 57,400 per month to rupees 55,200 per month after his promotion to the rank of inspector on 9/5/2022 by the impugned pay slip dated 19/8/2022 by recalculating his pay in accordance with Rule 13 of the 2010 rules is highly illegal, arbitrary, and in violation of principles of natural justice. Respondents could not have reduced the basic pay of the petitioner without issuing a show cause notice and affording him an opportunity of hearing before deciding to reduce his basic pay.
Okay, then what is this page 48? It's a joint representation.
This was Yorship by the Mizoram Armed Police Inspector Welfare. They had also submitted representations, Yorship. Now, the same reasoning was given, Yorship, for rejecting the representation.
What was the demand here?
Demand was, Yorship, same pay protection, which was already given to them as per Table 2, Rule 15.
This is on behalf of the association.
Welfare,
Welfare.
yes.
Which the petitioner is one of them.
Yes, he's the General Secretary. And Extra 11 is again a representation submitted by the Mizoram Armed Police Association, Yorship.
In Extra 11.
In Extra 11. English translation is at page 53.
What is the difference?
That is welfare. That is Sub-Inspector
Police.
Welfare. That is Mizoram Armed Police Sub-Inspector Welfare. And this is by the Mizoram Armed Police
Association.
Association. The reply is at page 57, Your Honor.
What do they say in serial number 3? Recovery of excess payment is required unless conditions of exemption are
Here-
fulfilled.
Here they adopted this. Here they have adopted this Government of India OM. This is that, Your Worship, this is the OM which says that if the pay was enjoyed for more than 2 years without any false representation from the person who's enjoying that higher pay,
2 years.
5 years. If it is more than 5,
So if it's more than 5 years, it should
Yeah,
not be recovered,
It should not be recovered.
which is in the basis of the
Supreme
judgment
Court.
of the Supreme Court.
Para 30 I've referred to you.
So why I'm leading you to all this representation is because you had raised about the principles of natural justice.
Yes, Your Honor.
You know what was coming to. It's not that it's a bolt from the blue.
Yes, Your Honor. But before they took the illegal action, let me put it that way. No show cause notice came.
So one is the welfare, one is the association, and one is your own individual.
Yes.
Where was that?
Mine is at page 37. Your Honor, Annexure 5 and Annexure 7 are my representations. I submitted these representations even before my promotion to inspector because I was anticipating the action to be taken by them, because in the case of my colleagues, they had already taken that said action.
You had already taken,
Yes,
that's why.
that is why.
So as far as pay is concerned, you have not benefited from promotion.
Yes.
Okay, let me hear.
Yes.
Mr. Saban.
May it please, my lord. Your lordship, this matter was forwarded by the Home Department to the Finance Department for clarification. Now, the reply of the Finance Department, which is at Annexure 4, page 16 of the affidavit in opposition, my lord. This was a letter addressed to the DGP, Mizoram Aizol, by the Undersecretary, Home Department. If I may read, my lord, the subject is pay grievances of sub-inspectors and drivers under Mizoram Police. Now, my lord, referring to the letter, with reference to your letter number and subject cited above, I am directed to convey herewith comments of Finance Department via ID number so-and-so dated August 2022 for your kind information. Number 1, promotion pay cannot be fixed against pay rules being enforced at the time of promotion, my lord. And secondly, to state why entry pay specifically prescribed for direct recruitment is claimed by employees who were not direct recruits, my lord. And at point number 3, recovery of excess payment of pay and allowances due to wrong fixation of pay is required unless conditions for exemption as stated in Government of India OMF number so-and-so dated 2/8/2016 are fulfilled by employees. And at point number 4, my lord, the department is also informed that this case has been examined many times. And since Finance Department cannot issue instruction as to pay fixation in violation of pay rules, the present decision is treated as final in this particular manner, my lord. This was the reply given, my lord.
So basically, this is the abstract of what the Finance Department had said.
Yes, your lordship. And the same was conveyed to the DGP by the Undersecretary Home Department, my lord. And secondly, my lord, the Mizoram revision of pay rules 2010 was made under the proviso to Article 309, my lord, of the Constitution of India. And as such, my lord, when fixation of pays are made, this ROP of 2010 has to be followed, my lord. And in the present case, fixation of the pay of the present petitioner is to be done as per Rule 13, my lord, of the ROP 2010. And in reply to the Somvir Rana and 12 others, my lord, which my colleague had stated out, my lord, the ruling, we have stated in paras 16, page 6, my lord. Right at the top, my lord. Page 6 of the affidavit in opposition, my lord.
Yes, what did you say?
We had stated that this case is not applicable to the present case because the present petitioner is governed by the Mizoram revision of pay rules 2010, my lord. And that he is not on the similar footing with the petitioners in the above mentioned case, my lord. Now, unless the state government adopts orders issued by the central government in service matters of its employees, my lord, the same cannot be automatically applied to the employees of the state government, my lord, because pay and allowances of state government employees need to be managed from the consolidated fund of the state, my lord, and not the consolidated fund of the central government.
So, is it an isolated case in case of the petitioner regarding fixation as per paragraph 15?
It may not be, but only the present petitioner has approached, my lord.
No, the refixation. In respect of others, sub-inspectors also, their
The
pay
same
was...
rules apply, my lord.
No, their pay was refixed
Yes, my lord.
as per paragraph 15. Or it was only the petitioner who got this benefit? I think others were there, that's why that representation.
Those were the.
There are a lot of representation.
Yes, my lord.
One by the welfare, one by the association, one by the petitioner individually.
With regards to other employees, I'll have to take instruction, my lord. At this stage, I do not know because only the present petitioner is before this court.
No, it's not required. See, the representation speaks for itself.
Yes, my lord.
Petitioner wanted pay protection even before he was promoted.
Yes, my lord.
Because others had already been given that kind of order by which their pay had been reduced. So the welfare took up the cause, association took up the cause. Your reply was that is as per 2010 rules,
Rule 13.
Rule 13 will apply.
Yes, my lord.
But this particular clarification which you just read out, what do you mean by promotion pay cannot be fixed against pay rules
Which would be the 2010 rules, my lord.
being in force at the time of promotion?
Meaning that fixation of pay, my lord, would be governed by the 2010 rules, my lord, and not against the 2010 rules. The revision of pay rules, 2010, my lord.
Okay.
Because Rule 13 specifically speaks of...
If 2010 rules were prevailing, it has to be fixed according to that.
Yes, ma'am. Because
Okay.
Rule 13 speaks of fixation of pay on promotion on or after 1/1/2006.
Mm-hmm.
Ma'am.
Your Worship, if I may give just one small submission, para 3 of this letter, recovery of excess payment of pay and allowances due to wrong fixation of pay is required unless conditions for exemption as stated in Government of India OM dated 2/8/16 are fulfilled. When it is convenient to them, they apply the central government OMs. When it is not convenient, they say we have not adopted it.
If I may, my lord,
these
if
are-
these rules were applied, there would be recovery, my lord. But these rules were not adopted, so there was no recovery made, my lord. It's not that we are blowing hot and cold, my lord. Mention has been made, but this were not applied, my lord.
Where's that OM? Page 78. Yes. What else?
And also we have stated in our additional affidavit, my lord, filed on 27/6/2024, that there are no separate pay band of direct recruit and pay band of promoting the post of sub-inspector of police, my lord.
Now, this is that OM 28/2016. Regarding recovery of excess pay.
Rafiq Masih and all that.
If we can adopt that, why can't they adopt the 2018 OM? That is also based on a Supreme Court ruling.
Yes, Mr. Samuel, you were saying?
Yes, my lord.
Additional affidavit.
Yes, my lord. Filed on 27/6/2024, my lord, stating that there are no separate pay bands for direct recruit and pay band of promoting the post of sub-inspector of police, my lord. Paragraph number 2, my lord, of the additional affidavit.
See, that's why pay ban may be one,
Yes, my lord.
but then the actual emoluments, after calculating all the increments and what all, not various heads, are calculated in total. It may vary.
Yes, my lord.
Pay band remains the same, but the amount actually received will be different.
Fixation of the pay is made as per the revision of pay 2010 Rule 13, ma'am. There it specifically states what calculations are made, ma'am.
Let's come to that Rule 13.
It would be at page 32 of the writ petition, ma'am. Page 32, my lord. Rule 13, fixation of pay on promotion on or after 1/1/2006. 13(1), my lord, if I may read.
Yes.
13 itself. In the case of promotion from one grade pay to another in the revised pay structure, the fixation will be done as follows. 1. One increment equal to 3% of the sum of the pay in the pay band, and the existing grade pay will be computed and rounded off to the next multiple of 10. This will be added to the existing pay in the pay band. The grade pay corresponding to the promotion post will thereafter be granted in addition to this pay in the pay band. In cases where promotion involves change in the pay band also, the same methodology will be followed. However, if the pay in the pay band after adding the increment is less than the minimum of the higher pay band to which promotion is taking place, pay in the pay band will be stepped to such minimum. A clarification note is given below, my lord.
This part, however, if the pay in the pay band,
After adding
the
increment is less than the minimum of the higher pay band to which promotion is taking place, pay in the pay band will be stepped to such minimum.
so there's also a provision for that.
Yes, this is the mode of calculation, ma'am.
On being promoted,
Yes, my lord. It is the case of the petitioner that he was promoted, my lord.
no, that's one. On being promoted, if the promoted employee, after adding all the
Increment.
increments in his pay band, is not even getting the minimum of the higher pay band to which he has been promoted, then adjustment or the step up can be done. After all, promotion means even your pay has to also go up.
Yes, ma'am. So our submission that he is governed by Rule 13, my lord, the present petitioner. Fixation of his pay, my lord, because of his promotion.
So, why was the query of the respondents at the relevant time like this in paragraph 6 of the writ petition? Have you got it? Paragraph 6. Just read.
Page 7, my lord.
Page 7, paragraph 6.
Yes, my lord. That when the pay of the petitioner was fixed by the respondents on his promotion to the rank of sub-inspector on 26/9/2008, as per Rule 13 of the 2010 rules, his pay as compared to the pay of the direct recruited sub-inspector fixed as per Table 2 of Rule 15 of the 2010 rules was much lower. Due to this, the then DDA in the police headquarters, in consultation with the respondent number 5, had fixed the pay band of the petitioner in PB to 9,300-34,800 by fixing his pay as GP 4,400 plus 10,520, equaling 14,920 in accordance with Table 2 of Rule 15 of the 2010 rules. Now, in reply to this particular paragraph, my lord, we had stated that the
Finance did not
now,
approve.
the pay fixation of the present petitioner was not approved by the finance department, my lord.
Okay, now this conversion of his pay to this amount which you just read out
Yes, my lord.
is like that. What should have been the conversion then at the relevant time? Under Rule 13. Comparison was drawn with the direct recruit. But Rule 13 provides that if the pay in the pay band after adding the increment is less than the minimum of the higher pay band to which promotion is taking place, pay in the pay band will be stepped up to such minimum. The minimum of the higher pay band. So if that was the case, why do they say that minus the finance department's view? Why do they say that he was getting lower? Perhaps that's because they were comparing his pay with the pay of the direct recruit.
And his pay was calculated as per Table 2 of Rule 15, my lord, which is entry pay for direct recruits, my lord.
That again connects us to that judgment of the Supreme Court or the tribunal.
Yes, my lord.
Why should one get lesser than what is given to a direct recruit? You forget the Supreme Court decision and the tribunal decision and the High Court decision in that regard, in that case. Without that, how do you justify? We have made the 2010 rules, okay. This is as per the 2008 revision of pay, the sixth pay revision.
The 2010 rules, my lord, as per my understanding, Rule 13 and 15, if we read, my lord, Rule 13 speaks of fixation of pay on promotion on or after. Now, if we come to Rule 15, my lord, Rule 15 speaks of entry of pay for direct recruits appointed on or after 1/1/2006, my lord. It would be at page 33 of the writ petition, my lord.
Correct. The pays are not similar.
Yes, my
This is the problem.
Yes, my lord.
Can there be two pay? One for direct recruits and one for promotees? 15, table 2 of 15, rule 15
Yes, my lord.
is the grade pay, pay ban and grade pay of direct recruits.
Yes, my lord.
4,400, isn't it?
Yes, my lord. Pay ban 2.
Pay ban 2. Now, insofar as the promotees are concerned, you say sub-rule,
13.1, my lord.
okay, 13.1 is applicable.
Yes, my lord.
Whatever the calculation is worked out
Yes, my lord.
as per 13.1, it is not equivalent to one which has been given in table 2 of 15. That is the grievance. So this was noticed way back in 2008 when he was promoted.
Yes, my lord.
So after consulting the respondent number 5, his pay was given in that as per 15 table 2.
And fixation of his pay, my lord, cannot be made in violation of the rules, my lord, upon calculation.
So rules are not challenged.
Rules are not challenged here, my lord.
Mr. Malhotra says rules are not required to be challenged. We have the Supreme Court judgment.
Because there are specific provisions, Rule 13 and 15, where calculations are to be made accordingly. Because this is a rule made under Article 309, my lord, of the Constitution of India. Now, if one is aggrieved by the mode of calculation or fixation of pay as provided by the rules, then the rules needs to be challenged.
Yes, what else?
That is my submission.
Mr. Malhotra, anything else?
Yes, Your Worship, main thing, rules have not been challenged. That is the main stand, I think. Even in the case of the trained graduate teachers, Somveer Rana's case, the Central CCS Rules 2008 was applied and there was one pay scale. But at the time of fixation of pay, for promotees, it was Rule 13. And for direct recruits, it was the section 2 of Part A of the first schedule. So that is why there were two different minimum pay. I mean, there were two entry pays, different entry pays for promotees and direct recruits. That is why the Supreme Court had said that the pay of the promotees should be stepped up. Even in those cases, the ROP 2008 central rules were not challenged. Although the pay of promotees was fixed as per Rule 13 of the 2008 rules, and the pay of direct recruits was fixed as per Section 2 of Part A of the first schedule of the 2008 rules. And in that case also, the rules were not challenged. The Supreme Court as well, the High Court held that the pay of the promotee should be stepped up. It cannot be lesser than the junior. So that is why, Your Worship, the necessity of challenging the rules does not arise. It is a case of where the pay of the promotee has been fixed lower than the pay of a direct recruit who is junior in the said post. So that is why, Your Worship, if I may take Your Lordship to the judgment of the High Court at page 74. The judgment starts from page 71. At page 74, para 7. When and after initial pay of promotee trained graduate teacher is fixed in terms of the order of the tribunal, increment would be calculated and payable as in cases covered by Section 2 of Part A of the first schedule of the rules as applicable to direct recruits. So here was a direction to step up the pay of the promotees. to the level of the direct recruits.
So what was the direction of the tribunal?
Page 69, para 12, Your Honor.
They should ensure that none of the applicant's pay is fixed at a stage lower than the pay which could be drawn by a direct recruit.
Appointee on or after 1/1/2006.
Stage. Pay is fixed at a stage
Lower than.
not lower than the pay given to a direct recruit.
So in these matters also, Your Worship, the rules were not challenged. It is just the implementation of the rules, which had led to a anomaly between the pay of a direct recruit and a promotee. And the tribunal as well as the High Court, Supreme Court had held that there cannot be a difference in the pay of a direct recruit and a promotee. That is why the pay of the promotee should be stepped up.
See, that's why I had referred to that table. Table 2 of Rule 15
Yes.
is ready-made. It's
Yes,
already there.
It is already there.
But Rule 13(1), some calculation has to be done.
Some calculation is involved.
So that calculation part ends with saying that, however, if the pay in the level pay after adding the increment is less than the minimum of the higher pay band to which promotion is taking place, pay in the pay band will be stepped up to such minimum.
Yes.
Minimum of the higher pay band. That means you cannot get something lesser than,
The table 2
yes.
of Rule 15.
So this perhaps is also inbuilt,
Yes, Your Honor.
but still your paragraph 6 continues to say that since he was getting lower than what was given to direct recruit, respondent number 5 advised him to act according to table 2 Rule 15. Is there some anomaly in the calculation at that relevant time? I don't know why this particular provision has been.
Yeah, the main thing is interpretation of Rule 13 and Table 2 Rule 15. If they had correctly interpreted Rule 13, which Your Lordship has just read, however, the pay in the pay band after adding the pay increment is less than the minimum of the higher pay band to which promotion is taking place, pay in the pay band will be stepped up to such minimum. If this part was implemented, I don't think there would have been any problem.
13(1) applied.
Yes.
It is found that it is lesser.
Yes.
Just step it up.
Step it up.
We applied 13(1) and we stepped it up because it's lesser.
Yes.
Not that you say that I applied 15 table 2. Anyway, this issues on pay is not so simple.
Your Lordship will see page 55 of the writ petition. That also gives an indication that why the pay was
Page
55. And this was a letter written by the PHQ to the Undersecretary Home Department. They had forwarded the representation submitted by the President of the Mizoram Armed Police Association.
Is the type copy okay? Page 56.
Yes, Your Worship.
This was in 2022.
Yes. This has a reference to representations regarding grievances of pay submitted by Sub-Inspector Armed Branch and driver associations under Police Department, which are enclosed herewith. That on implementation of the Mizoram Revision of Pay Rules 2010, pay of Havildar and driver promoted respectively to Sub-Inspector Armed Branch and various grades, special grade, grade 1 and grade 2, were fixed as per Table 2 of Mizoram Revision of Pay Rules 2010 with the approval of the then Deputy Director of Accounts, Police Headquarters. However, such fixation of pay are not accepted by Accounts and Treasury Government of Mizoram when their pension cases are processed, resulting in recovery of certain sum of money from the pensioners. Illustration of pay in respect of Rauchara, inspectors enclosed herewith for ready reference. So, they themselves, while applying Rule 13 and Table 2 of Rule 15, at the time of promotion of the petitioner as well as his counterparts to sub-inspector, it sort of struck them that the pay of a promotee is lower than the pay of direct recruit. That is why Table 2 was applied. But then subsequently, after they were promoted to inspector, then they started taking action that no, Rule 13 should have been applied. This is not right.
With your permission,
13.1 involves some calculation.
Yes.
You cannot get lesser than what is the minimum in the next higher grade.
Yeah.
That step up was also required under this 13.1. Instead, they opted for the ready-made formula,
Ready-made formula.
it seems. Yes, Mr. Samuel, you are saying.
with your permission, my lord, if I can draw your lordship's attention to page 6, paragraph 18 of the affidavit in opposition filed by us, my lord.
Page 6.
Paragraph 18, my lord. The last
Yes,
paragraph, my lord. If I may read, my lord.
yes.
With regards to the statements made in paragraph number 26 of the writ petition, I state that the present case should not be confused as different pay scales for the same post, my lord. It is the case of pay fixation method, my lord. The pay scale of sub-inspector of police is pay band 2, grade pay 4,400, 9,300-34,800 for both direct recruits and promotees, which can be clearly seen from serial number 475-478 at page 57 of the Mizoram Revision of Pay Rules 2010. There is no separate pay scale for direct recruits and promotee. Hence, the allegation that there are two different pay scales for the same post is not true. Now, my lord, if we look at the additional affidavit filed by us, my lord, at page 27,
Yes.
at serial 475, my lord, sub-inspector new entry. 478 is sub-inspector. So they are not different pay bands, my lord.
Have you indicated anywhere
Yes, my lord.
that the calculation of pay of the petitioner in 2008
Calculations have not been included in our affidavit.
should have been this much and not what he was getting as per table 2?
Your Lordship will kindly allow me to page 7 of the affidavit. Para 20,
Yes.
the last paragraph. The pay scale of direct recruits and promotees is pay band 2, so and so. There are no separate pay scales for direct recruits and promotees, which can be clearly seen from serial number 475 and 478 at page 57. Though method of pay fixation in promotion and entry of direct recruits on the appointment are not same, their pay scale is identical. This is where the problem cropped up, Your Worship. Method of pay fixation. Rule 13, Table 2, Rule 15. That is why the problem cropped up. And that is why when our pay was fixed, when I was promoted to SI, they saw that although the pay scale is same, my pay is lower than the direct recruit pay. So that is why I was allowed to enjoy the pay of a direct recruit, table 2, rule 50. And
Pay band same, grade pay same,
everything same.
but then
Identical.
But then are the other, what do you call, the other benefits,
Increment.
the increments
Whatever.
and all that, when you add it up, there's difference. But how does it happen that the direct recruit is getting more? Because they are just stepping into they have just entered into the service. There's no question of them having increments on the first day. Unlike those nurses and all that who was getting master degree and getting 2 advanced increments.
That has not been explained by them, Your Worship. How come the direct recruit was getting a higher pay?
And yet you say that it's the same band,
Yeah. Identical
same
pay scale.
identical pay scale, same pay band, same grade pay.
But fixation of pay is done as per the ROP 2010. That is what we submit. Rule 13 and 15.
Understood. That's why I say 13.1 says that you
Yes,
can
ma'am.
bring it up. Anyway, we'll consider and see what can be done.
Obliged, ma'am.
Please write down. Heard Mr. A.R. Malhotra, learned counsel for the petitioner, and Mr. Samuel Banlavshi Atatsangte, learned additional advocate general for the respondents. Parties have made their respective submissions. Hearing concluded, judgment reserved.
Obliged.
Item number 9.
Lordship, I'm appearing on behalf of Mr. Bilaram Enga. We have filed a affidavit in opposition this morning for the respondent number 5 and 6.
My lord, I have received the counter affidavit, my lord.
What about the others?
The others, my lord, they are yet to file, but my main grievance in this revision petition is against the respondents number 5 and 6.
State is not a pro forma. The branch manager, rural bank is a pro forma. They are 7 and 8. State is 1, 2. According to you, you're a pro forma. According to them, the bank is a pro forma. So-
1, 2, and 4 are the state, my lord.
What is the matter regarding?
My lord, I have filed an application under Order 38, Rule 5 and 6 CPC for attachment of the bank accounts of the respondents number 5 and 6. But that was dismissed by the learned trial court, my lord.
Okay,
So I have challenged the order. So, my lord,
you want to file reply?
if I may be given liberty, my lord, and in the meantime, I was speaking with Mr. Bilaram Enga that the matter may be listed on 21st of October, my lord.
It's agreeable to him also?
Yes, my lord.
Lordship.
Your good name, please?
Lalmun Moye
Ms. Lalmun Moy, learned counsel appearing for respondent numbers 5
and 6.
5 and 6. Submits that counter affidavit has been filed this morning. and a copy of the same has been served to the learned counsel for the petitioner. Stop. Mr. Samuel Vangashi Datsangte, learned additional AG, appearing for the state respondent, submits that the state respondents are basically a pro forma respondent. Stop. Mr. C. Tanthiantima, learned counsel for the petitioner, submits that he may be given some time to go through the counter affidavit and file, and also file a rejoinder affidavit if so required. Stop. The prayer is allowed. Next para, in view of above, and as agreed to by the parties, list the matter again on
21st of October.
21st of October 2024.
In the meantime, my lord, if the interim may continue.
Interim order passed today shall continue till the next date of listing.
Oblige.
For hearing, item number 13.
Who are the parties? Second appeal.
Yes, my lord. My lord, this can be converted as regular first appeal if may, considering that the rules also Pachunga versus Zokumi case, and in many cases, RSA of District Council Court judgments were appeal were converted as RFA. Pachunga, Lianmoi, and Chiapai. I have some 2-3 judgments.
What have you challenged here?
I challenge, my lord, District Council Court Order 29/2020.
Order of the District Council Court.
Yes, and also I challenge also the trial court also both.
Which District Council Court?
Mara Autonomous District Council Court.
What about that clause 3 of the Assam High Court jurisdiction
Yes.
over the District Council Court?
Yes, I under that provision I challenge.
Under that provision?
Yes.
So this is not a RSA in the true sense of the term?
Yeah, normally.
It'll be an RFA only?
Yes, normally, because there are many instances where.
There's no question of converting it.
Excellent.
If we are clear about the fact that it is against the order of the District Council Court, and it's under that provision that you have filed although it may be given a nomenclature as RSA,
Yes,
still court can go into the facts.
definitely. Even evidence also.
Yes, evidence, correct. Where's the impugned judgment? Just show me that first.
My lord, paper book, may I kindly refer paper book? There's 113.
Paper book 113. Both parties are ready?
Yes, my lord.
Okay, Dika, and both of you, you can leave. I'll call you up if it's when you're ready.
Actually, this order is nothing but just simply affirm the trial court order by one sentence only.
113.
Yes.
Please read.
113. Today is fixed for appearance and hearing of the parties. Both parties are present before the court through their respective counsels, heard the parties in length. On perusal of the case record and hearing of the parties, this court is of the opinion that lower court has decided the instant case before it on merit on the basis of the natures of the case, customary law of Maras, and the principle of natural justice. Accordingly, this court has upheld judgment and order of the lower court dated 19/6/2020 in the interest of justice. However, the period fixed for vacations of the residential building by the appellant, Lalrin Moy, may be deferred to another 30 days from the date of issue of this order. Very short and simple. Because then that subcourt and all, normally they are not law graduate and all, they just refer, normally it is like this. The judgment is at Lordship, paper book 93.
The trial court.
Yes.
Yes. What is the date, 17 or 19?
Lordship,
Date
it
of
is
the
on,
judgment?
date of the judgment is 19/6/2020.
19.
19/6/2020.
Because there's an overwriting, that's why.
Yes, in this respect also in our main contention is the will. There's a lot of overwriting and there's some, it is not signed also, very important.
Date of the judgment or the order of the, in the heirship case.
This is date of the judgment in respect of the heirship case is 19/6/2020.
Do we have the LCR? Just check out the order sheet in the LCR of the trial court. That means magistrate's court, SDCC. (19:6), isn't it?
Yes, 19/6/2020.
Today is the date fixed for judgment and order. Both parties are present before the court through their respective counsel. Accordingly, judgment and orders already prepared is pronounced in open court, presence of both parties. Okay. 19:6. Yes, what is the dispute?
My lord,
regarding-
the dispute is that my father's property, my husband's property. So that the very simple question I can say is that whether my brother could inherit the property of my husband, because
Okay. You are the defendant in this,
I'm the defendant.
in the heirship case?
Yes.
Defendant.
And my brother-in-law and apply for heirship certificate in respect of the property which was already settled in my husband's name.
Okay, the applicants here are Silalun Thanga and Benji.
Benji is the son of my husband to another woman. But Benji here did not
Your
contest.
stepson.
Yes,
He's your stepson.
stepson
Then Silalun Thanga,
is my brother-in-law. My
Brother.
husband brother.
brother-in-law. What is the property?
The property is two standing building. One is Assam type and residential ancestral property. One is the shop, the RCC building that is covered under MRL Mara Land Record 438 and 439 2014. My lord, we can see from the annexures in a chronology from the heirship application itself. So everything will be clear. There are very short
Page.
questions involved.
Page.
It starts from a 9.
Page 9.
Yes.
See, you must submit on the facts,
All
the
right.
basic facts of the case first.
Yes, Lordship. Here, my husband had a property in the year 1975. This is at Annexure 1,
Page?
9. So if you see that one also, the name of the settlement holder, he is my husband,
Who is he? No, no.
Lal Nun Kluanga. So if you see the next page also at the top corner, Lal Nun Kluanga. This already belonged to my husband in 1975. And if you,
What is this? It's a will.
the next is actually, they call it is a will. Because of this, on the basis of this will, they inherit all the properties of my husband. Because here, it is nowhere written in respect of which property. Nowhere written that LSE number, SOC pass number. There is no detailed descriptions of that one also. Even Your Lordship, there are two wills on the same date. This is we really object to this will also. On 2012, this is their application. On 2012, 1990. So in 1975, it was already in the name of my husband.
Okay, where is the heirship application?
Application is that it starts from paper book number 1.
1.
Yes.
What is the name of your husband?
Lal Nun Kluanga.
Then who is this C. Kimi?
My father-in-law.
Your husband's
Father, yes. Is the one executed the will also.
So you come to page number 2.
Yes.
He has a plot of land bearing PS shop so and so.
Yes.
This is one property.
Yes.
At New Siaha,
Yes.
Siaha, covering an area of 4 by 25 hectare. What does it mean?
Actually, 4 into 4 in that 44 meter, but this is also wrong. In my written statement also I clarify.
The past number is correct?
Past number is correct.
71 of 75, dated 12/11/75.
But it was, this was mutated in 1990 in my father's name, husband name, again in 2014 also. It into Mara land record number, 2 times again.
Then she constructed 2 Assam type building
Yes.
on the shop line. And the rest of the land remain as house, residential garden. Please read this plaint,
From
paragraph 3.
3. On the said plot of land, Kimi Kwangmoya late had during his lifetime constructed to a some type building on the shop line, and the rest of the land remained as the house residential garden. On the buildings was one of the building was used for their own residence, and the other was occupied by other persons on rent. Number 4, since the area of the land covered by House Pass PS Shop 1975 was large, Sheikh Himi late had during his lifetime given some portions of house residential gardens separately to his two daughters, namely Gurchini and Biaknuni.
Okay, just stop there. They are not in the picture now, no?
Yes,
He had already given.
yes,
So this PS shop pass covered a large area. He constructed two Assam type building
yes,
and some was remain as a garden.
yes,
Later on, he gave separately to his two daughters.
yes.
That much is not disputed. Not disputed.
Now we disputed because they did not enjoy, they did not occupy at all. It was just, a concord story is our version.
Okay, then number 5.
That since Kimi had only two sons, he during his lifetime had also distributed his property between his two sons in the presence of witnesses and other family members by executive semna or will. In this regard, it is necessary to point out that Kimi firstly executed semna or will in handwritten form, and the same was signed by him and witnesses. After that, handwritten will was upgraded into typewritten form. One drafted copy of the said semna of or will was kept by the plaintiff number 1, which was not signed by the witnesses, and the other copy of Rosemna of will was kept by one of the witnesses, Sri C. Sangnuya, which was signed by the witnesses. However, at the time of submitting objection against heirship certificate, application copy of Rosemna or will kept by C. Sangnuna could not be found, but it was found later.
Who are the two sons? One is your husband, late husband.
One is my late husband, one is brother, my brother-in-law.
Brother-in-law.
My husband's brother.
Who is the applicant number 1?
Applicant number 1 is my brother-in-law.
He and your late husband, they are brothers.
Yes.
Who's the elder one?
I'm the elder one.
You're the elder one.
Yes.
I mean, your husband.
Yes.
Okay. Then
Here, why the okay 6. The properties of which Sikh Himi had given to Lal Nunkluang at relevant times were newly constructed Assam type building located in the northern side of his shop line, 2 as BBL gun, 3 2 alumna spots. Number 7. The properties which Himi had given to Sri Lal Nunthanga at relevant times were old Assam type building located in southern side of his land, shop line. And that, my lord, in my paper book, it is not clear. May I skip? Number 2. 3. House residential garden. 4. Household property, including chair, wardrobe, utensil box. 8. That Sri Khimi also stated that some of the properties which he had already given to his two daughters shall not be disturbed by his two sons. And Khimi died on 31st December 1990. After the death of, my lord, kindly note that will was executed on 20th 12 1990. He passed away after like 7 days.
where's the date?
Will was executed. Oh, it was not written in para 5, but in the body of the will it is there.
Then he died on which date?
Died on 31st December. Just only 7 days. All right.
And the will is dated?
Will is dated 20th 12 1990.
2012,
Yes.
1990.
Yes. May
Yes.
may I please 6. Number 10. After the death of Sikh Himi, his wife Monkey and his two sons and sold some portions of house garden, constructed another building in the year 1995 within the coverage of pass number such and such. After completion of the said Assam type building, Monkey late with his two sons and unmarried daughter shifted to their new building, and the other two buildings was occupied by other persons on rent. The applicant number 1, Lal Nunthanga, married in 1997, and since his wife was a government servant who was posted at Longklai, they left their home in Pui in 1997 for better convenience of the office service of his wife and returned to Saiha in the month of February 2019 after his wife was posted at Saiha. So this is very relevant. Father passed away in 1990 and he got married in 1997 and shifted to Longklai, where his wife was posted There he constructed his own house, lived there. He came back only on February 2019. And this case was filed in July. So it seems like he came back just to file this case. And he was away all through the years. In the year 2005, when the applicant number 1 family was residing at Longtai, Cyril Nuntruanga informed the applicant number 1 to construct a new building on one of the shop line, which his late father had given to him as all Assamtai building was too old. This time, applicant number 1 purchased necessary materials like road, cement, etc. and transported to Saiha from Longtai. When the plaintiff number 1 decided to start construction, his elder brother, Cyril Nuntruanga, disturbed him by making one or the other pretext and also got angry with the applicant number 1. Since the applicant number 1 did not want to make misunderstanding with him, and his elder brother, Cyril Nuntruanga, did not construct the house and taken back his material to Longtai at that time. That Simati Monkey died in 2013. She's their mother. 2013. Cyril Nuntruanga late had 7 children, 2 sons and 5 daughters out of 4 wives. The applicant number 2 is the son of Cyril Nuntruanga and also grandson of Kimi. Lal Nuntruanga unexpectedly died on 1st May 2018. At this time, the applicant number 1 came to know that his elder brother constructed concrete building within the area of the 2 old shop line Assamtai building. On further inquiry, applicant number 1 also came to know that the land passes of Kimi was fragmented into 2 LSC and mutated in favor of Cyril Nuntruanga, namely LSC number 1997 and MLR, I think MLR means Mara Land Record, 2014. So the applicant number 1 further came to know that his elder brother had sold some portion of their residential house garden. So before 2018, he already constructed the building, everything. This is the suit property. And they did not even spend even a single rupee for construction of the suit property, and he came to know only when the building was already constructed. After the death of Cyril Nuntruanga, late applicants and other near relatives tried to have discussion many times with the defendant regarding the landed property left by Kimi and other property left by Lal Nuntruanga, but defendant always refused to have discussion. That surprisingly, defendant had applied for heirship certificate in respect of land pass number such and such, but since applicant number 1 and 2 submitted objection against the said heirship certificate, this honorable court rejected the same. That since discussion could not be held, defendant, the applicant, and other relative had a meeting and resolved as follows. What is very surprising is that this meeting of the family members is never dated. It does never have a date. It was also done in our absence. The present shop line concrete building shall be divided between the 2 sons of Lal Nuntruanga, namely Lamdin Puya Chinza and Benji Vanal Sriat Puya, PW number 2, 50-50, and 2 separate parts shall be made out from the said shop land. The present Assamtai building in Pui with its land shall be owned by the applicant number 1. The respondent, defendant, and her 3 daughters shall reside and settle at the basement floor of the shop line concrete building. The respondent, defendant shall reside in the said basement floor of the shop line concrete until marriage or till that. In case of remarriage or respondent, defendant unwillingly to look after her 3 daughters, the applicant shall look after the 3 daughters. Since the shop line concrete building was constructed by availing loan and the unpaid loan remain around 10 lakhs, all the rent from the shop shall be collected by the respondent and her 3 daughters. Loans shall be repaid regularly at 40,000 from the shop rent from the month of July 2019. After full repayment of the loan, defendant, respondent, and her 3 daughters shall collect 4 ground floor shop rent or 4 rooms of shop. In case of remarriage of the respondent, defendant, her 3 daughters shall be looked after by their paternal uncle, applicant number 1. The remaining 2 shop ground floor shop rent and the first floor rent shall be divided between the applicant 1 and 2. That since no discussion could be held with the defendant regarding the landed property left by Sri Kyomo, the other property left by Sri Sil Nunthanga, applicant filed this instant suit. Since the Ramdin Puya Chinza, one of the sons of Lal Nuntruanga, permanently live in Zemabok Aizol with his mother in their own residential building, he is not much interested in the said properties and is unwilling to be a party in the suit. Therefore, he is not included in either of the side in the suit. This suit, and this is very important, the prayer is prayer 1. Let a decree be passed awarding the applicant number 1 the share of the landed property which was given to him by Rosemna or will. That Rosemna or will dated 20th 12th to 1990 of Sri Kimi, and also to award applicant number 2 the share of the landed property which was given to his father Sila Nuntruanga by Rosemna or will Sikimi. And or, this is or, not and. In the alternate, let a decree be passed awarding each applicant their respective share in the family meeting resolution. Because the family resolution did not have any date, it was done in our absence. So, my lord, here the application, heirship application, is praying for the properties on the basis of the will. So, if you kindly see the property, initially it was not in the name of the one who executed the will.
For
Yes.
probate of the will?
Exactly also.
No. Is it for probate of the will or it's a heirship certificate?
Heirship certificate on the base of the will. That is not possible also, because first it has to be probated first.
But the parties have all contested, is it?
Yes.
The brother, the stepson.
All interested parties.
This number 2 is son of, who's son of?
Son of my husband.
Okay.
My stepson. But who
Stepson.
never resided with us.
And who is this Ramdin Puya?
Ramdin Puya, Benji.
Ramdin
He is also stepson, but he resided in Aizol. He's not interested in the
Okay.
property.
Stepson.
Yes.
Okay. How many will has been made?
2, but they're exactly same, except they're some a little bit different. In annexure 2 and 3.
If it's exactly different, same, then how can it be a little bit different again?
No, actually, it was witnessed as they admitted in their petition also. It was not signed. Another was not signed by the witness, and one was signed by the witness.
Only the signature of witnesses
Yes.
are different.
Yes.
Otherwise, the contents of the
The
division.
content are, because they put another handwritten also in the meantime. In type copy, we cannot see handwritten, but if the copy you have, the copy in that original application form, the handwritten will be very clear. But
Okay.
in,
So heirship certificate was, application for heirship was filed.
yes,
This is under Rule 21,
Yes.
Rule 45, 47. What is that rule?
my lord, actually that rule, I don't have the rule, but normally this provision is used for applying heirship certificate. We have not disputed the rule, but which we dispute is the will, the validity of the will. And also, he is not competent to execute the will in the property which
No.
he is not the owner.
But this court is required to also understand what is that rule. Mr. Malhotra, you are aware of this rule? What book is that? Is there a provision for heirship? Page number?
276.
Lakher Autonomous District Administrative Justice Rule 1981. Rule 21. Shall be competent to try all suits. Then 45. according to justice, equity, and good conscience. Then 47, spirit of CPC. So basically, it's like administrative justice rules.
Yeah, because even in our written statement also, we never dispute that the application, the provisions of law.
According to law, justice, equity, and good conscience, CPC will be applied in spirits. Then 21 says, subordinate district council court is competent to try all suits arising out of district. 22. So this is only a general provision, I think.
Yes.
Nothing specific about it. Then
So if you kindly,
after filing of this suit or headship certificate, you file your WS,
yes,
isn't it?
yes, my lord, I want, if you kindly see the original copy of the will, if you see what is the difference, because the paper book is only the type copy one. If you see you'll see the difference.
Where is the will in the paper book first? You show me that.
Annex,
Page,
it is at, I think 9 I have read. 10,
the will.
the will,
That is at page 10.
yes, of the paper book. Very small pleading.
This is a typed copy.
Yes, type copy, that's right. But in original copy, that they put that D and handwritten one. That is why I want to say. Because in the type copy, there's no difference.
No, my question was how many wills are there?
2. The next one is Annexure 3R. Another
2
will.
wills.
Yes. On the same date,
And relating to how many properties?
it's same properties.
Landed property.
Yes. What the discrepancy I pointed out is that one, the second annexure number 3, here witnesses did not put their respective signature. Even that also they admitted in their application.
This is the same thing.
Same thing,
Page 10 and page 11.
yes. But if you see at witnesses, Kam Loba did not put signature. Sang Noya did not put signature.
In which one?
In the second one, the second will.
Page 11.
Yes,
See, page 10 is exhibit P2.
yes.
Page 11 is exhibit P3.
Yeah, that's why, Your Lordship, I want you to see the original copy from the application form, because this is typed by the registry. When typed, they cannot put signature. You'll be clarified. In the original application, they are annexed 2 and 3.
Can't find it out.
I just have checked a few moments back.
Give it to him. You just flag it. Oh, just a minute, it's here. But this is RFA. Must be in that only, not in this. What is this?
Annexure 2 is the one with signatures of the witness, and Annexure 3 is without signature of the witnesses.
Red flag.
The next one,
Next one means?
red flag is Annexure 1.
No, you wanted to show me the will.
Yes, the will.
Where is the will?
I flag it, Your Lordship.
With what color?
I think red.
Red one says boundary description. I think this is a pass.
I think the next, just the next one. Annexure 2.
Yes, what is this? On the top?
Rosemna.
Okay, Rosemna.
Yes.
Yes.
Yes. When it is typed, they don't include the signature and the handwritten part. That's why I want you to see that one.
Which handwritten part?
Handwritten part is at D. And also here you see witnesses. Kamlova, C. Sangnoya. They put their respective signatures.
Okay.
And if you turn to Annexure 3, though it looks exactly same or similar, here if you see the signatures of witnesses, they are blank. So my question is that how can original will or a will can have these two types of form? One with signatures of witnesses, another with signatures of witnesses. And also
Otherwise, the contents are same?
same, but same at D a little bit different, but I don't dispute much how it was written and the position. But what is very glaring illegality is that all through the proceeding, this original copy was never ever produced in the court or never exhibited.
Which original copy?
These two, either one or two.
These two will copies.
Yes.
But it's not a probate case. It's a heirship case.
But anyway, heirship, they apply on the basis of this will. Because
some basis is required to give heirship certificate.
yes, definitely.
But then the heirship also is decided in such a manner that the properties are distributed.
And they
How did the trial court decide it?
trial court decide we are directed to vacate the building ancestral property, and the trial court validated the will also. And also there are two issues, important issues. The issues are, Your Lordship, can I kindly turn to the paper book, the issues? Page number 40.
See, the heirship application was filed,
Yes,
then you filed your WS,
yes.
then you examined any witness?
Yes.
How many witnesses?
No, I examine only myself.
Okay, and the applicants?
They examine, I think, 6 witnesses. Or 7 or 1. My lord, my main contention in my written statement.
Just a minute, we'll go step by step. Applicants examine 6 prosecution.
My lord, I'll just confirm it. 7 witnesses.
7 witnesses. And you did not, defendant did not examine any witness, only yourself.
Only one myself.
Thereafter, the trial court passed the judgment
Yes.
at page 93.
Yes. My lord, before going to trial court, allow me to just explain my content of my written statement. A very brief, because I don't have much defense. Only 2-3 points I have in my written statement.
Where is your WS?
WF start from
Page 17.
yes.
Your WS runs into about 6 pages.
Yes, but it's the contents are very short. One point is that, my lord, 1975 was my husband passed, and that my father-in-law did not have any right to make a will on the property in which he is not the owner. This is one point. And second, my second contention is that
Yes.
that 1975 pass was again divided into 2 passes in 1990 and 1997. Again, those 2 passes were later on converted into LSC in the year 2014. So my contention is that here the respondent did not have any right to apply for inheritance in respect of the property of my husband. See, their application itself, they pray on the basis of Turochia. Yes, which was executed on 20th 12 1990, just some 9 days before he passed away. That time, the property was not in his name. Even if you carefully look into the Rosemna, you will not see anywhere the pass number. He just simply distributed. At least it should have the pass, whether it is LSC or SOP pass or VC pass.
So there's only one landed property, correct?
Initially, there is only one 1975 pass. It was mutated into 2 passes in 1990.
Whose name?
In my husband's name.
Both the passes?
Both the passes.
Okay.
And again, that 2 passes also again make into LSC. 438 LSC and 439 LSC again.
In which year?
In 2014.
2014. In whose name?
In my husband's name only.
When did he expire?
He expired in 2015 May.
Okay, after the LSC was...
Yes, yes.
And now heirship has been claimed by the respondents
Yes.
on the basis of that 1990
Yes.
Rosemna will.
Yes. In respect of the property of 1975. Where it was never existed anymore.
Okay.
This is my contention.
So where did you state that in your WS?
WS. Man, from 7. para number 7. May I kindly read?
Yes.
The contents of para number 2 of the suit are totally denied and objected. The fact is that defendant late husband Sri Cyril Nunthanga had a plot of land bearing pass number PS Shop 1975 of 12/10/1975 at New Siaha, as it was very clear and evidence from the annexure 1 of the plaintiffs, and that the said land owned by the defendant late husband at New Siaha was 40 m into 40 m and not as claimed by the plaintiff, which was 44 m and 44 m. That the defendant late husband during his lifetime had divided the suit land and mutated in his name bearing pass number PS number 2890 of 1990, measuring such area this much, which later on converted into MLR, I think this is Mara land record, on 22/5/2014. So one part was mutated in 1990. Again, that pass LSU was again renumbered as MLR 438. That is one part. And another part, because that the original land was distributed into two parts, and another plot of land bearing pass number LSC 697 of 8/8/1977, which was later on renumbered as LSC shop pass number 88/1998, measuring an area such and such, later on converted into MLR of 22/5/2014. This is 439. For the sake of brevity, I can say 439. So that.
So originally 1975.
Yes.
Thereafter, it was mutated in the name of your husband.
Yes, on two parts.
And it was then. When was it divided?
Divided on one part is on 90, another part is on 99, and that was it in LSC. My Lord, I have clearly making a tabular form in my grounds of appeal to better understand in my memo of appeal, so that you'll understand in 120 of my paper book. Here I make a table. This is a bit confusing, that's why I make this table. 120 of the paper book.
Yes.
Here, this is how it comes.
1975.
Yes.
One part is 1990.
Yes. Again,
The other part is 1997.
Yes. Actually, this is the same plot, but they just changed the name. Before, it was not MLR. LSC was renamed as MLR.
So 1975, then 1990.
Yes.
And also 1997.
Yes. 1990. Yes.
Now, how can that be?
No, there are two plots of land.
When was it divided?
One is in 1990.
No, if you divide this 1975 plot of land into
Yes.
two parts,
Yes. But actually, normally.
division will take in one day only. How can it be divided one in 1990 and again division in
My
1997?
Lord, I can only rely upon the body of the past, because so far I have enclosed the annexure in my annexure 1, 2, 3, 4, and 5.
So things are all jumbled up. I don't know.
My Lord,
Okay.
I just refer from the body of the passes. So the reason why I submitted this point is that the respondent, he left in 1997. He stayed in Long Klai, settles his own family where his wife is working, never came back. That time I've been looking after the home, everything. So I managed everything of this thing, and all the bifurcation also I did. They admitted that I constructed the building also. They never disturbed me. And he came back just to file this case in 2019 February. So he has never challenged all this kind of partition or whatever, the settlement, everything. He has never challenged. But when I applied heirship certificate and he made application to the court, not to grant heirship because this property which was illegally distributed, we are taking step. He admitted that. It is there in the application also. There he filed a letter to the court. So there, wherein but he never challenged all this kind of mutation or partition, whatever. So how can he apply heirship certificate belatedly on 2019 after passing away of my husband in respect of the property which was never existed? Because 1975, it was already no more existed. Again, 1990, again it was converted into land settlement in 2014. And I constructed building, some type RCC building also. I had taken loan. I had been repaying loan also. Then they trying to evict me. In fact, the order itself is for eviction of us.
So is there any stay order in your
Yes,
favor?
my lord, you passed the stay order.
There's a stay order.
Yes.
See, we'll do one thing. We cannot complete the hearing today. We'll have it again some other day.
My lord, when can we have? Can we have on Wednesday?
Wednesday, I think we have a division bench.
Or,
That's why.
yes, I got it.
We'll have it on Thursday.
Fine, yes.
Okay. Mr. Malhotra,
Yes, sir.
you are there for the respondent.
Yes.
But respondent number 2, he did not contest the appeal.
How many respondents are there?
2, that my stepson and my brother-in-law.
Stepson is not contested.
Yes,
Only your brother-in-law.
yes.
What happened in the partition, in the heirship certificate? He did not get any share. That's why he did not contest. He's not contesting.
My lord, it's quite unfair. It's like totally they are trying to evict us after passing away of my husband in the property we have been living since long time back, where our kids were born. This is the thing.
Okay. List the matter again on Thursday. Please give the date.
Much obliged.
This is from here. Say for hearing, okay? Thursday for hearing.